শুভ বিজয়া দশমী
Yes, Shubho Vijaya.
on an urgent, with extreme urgency, my lord, a doctor's chambers having 44 years practice, homeopathy doctor, my chamber has been forcibly stopped by local miscreants, spearheaded by the local councillor along with the chairman of the Northern municipality. I moved this matter. My leave has been granted to move the regular bench, my lord.
When did you seek for leave?
My lord, on 16th, my lord.
16th. And since when is this closed?
My lord, 12th onwards.
Very well. It will appear in the list.
Well, I served the advance copy, my lord.
Yes. Monday it will appear?
Monday.
Today I do not know your other side is there or not. Ensure that your other side is there.
Yes, my lord.
Monday it will appear as urgent
And
motion.
my lord, along on supplementary video, I shall file on that.
Serve that also. Supplementary also you serve.
Yes, my lord.
File it.
Maybe
Supplementary at the time of filing.
But only leave to be granted to file.
Leave has been granted.
Leave has been granted to move the regular bench.
Move the regular way or further leave. Monday it will appear. Urgent.
May I have my lord kindly, my lord, seeking listing of an application, my lord.
Give.
My lord, may I have my lord's leave, my lord? I'm praying for upgradation of a matter, my lord. My lord, in this matter, petitioner number 1.
Where is the matter?
My lord, in the September's monthly list as item 847, my lord, there's some urgency. The petition number 1 had wrongly remitted the amount to another account. My lord, instead of the account number 1234, it was typed as 1243. And they've been writing continuously to banks and all the amount is lying in the bank. But the bank is not doing anything. Ombudsman has refused to intervene, my lord. That it has been filed any day convenient to my lord, may it appear, my lord.
Who will be the answering respondent in the bank?
The banks, my lord, and my lord, the commercial tax officer, because the account has been earmarked by the tax officer. We have written to
And
tax.
why will it come here?
My lord,
will it
because
not
it's
go
a
before the...
residuary matter, my lord.
Are you sure?
Yes,
Because
my
you
lord.
say
Yes,
that
my
the
lord.
taxing
No,
authorities
my
are
lord, it's
involved.
not the taxing matter, my lord.
Very well. In that case, it will appear on Tuesday. Serve notice.
Yes, my
I
lord.
permitted to mention one matter, my lord, which was, my lord, listed before the vacation bench, but because of paucity of time, it could not be taken up, my lord. My lord, matter relates to, my lord, setting up of a sawmill in front of my house, causing sort of...
Has it been set up already?
Yes, my lord, started functioning, my lord.
It has started functioning. Then it will appear in the combined list.
My lord, this urgency because dust and without any permit, and it was, my lord, about to, it was listed before the vacation bench.
Whatever. Now it has not been taken up. So, monthly list.
Your lordship. Another, my lord,
Serve notice. Serve notice.
One more thing, my lord.
Monthly list urgent motion. Monthly list urgent motion.
But extension of interim order, my lord, interim order is expiring on 25th, my lord. This is relates to, my lord, courtroom number 3. Your lordship is having determination of today, my lord. Demolition order, my lord, has been...
Then please mention before the regular bench.
Lordship, I mentioned on matter. This is matter. This was filed with the leave of the court before the vacation bench and moved before the vacation bench. Now the interim order is expiring on Monday. Lordship, that is 27th. This is a residuary matter. That is why I'm mentioning before Lordship for extension.
27th interim order is expiring.
Till has been granted till 27th.
Yes, that means till 27th. And who is your other side?
KMDA, your lordship.
KMDA matter. All right, give extension, serve notice.
Your lordship, may I permit you to mentioning for the upgradation of the matter?
What is the urgency?
As it was urgent for the urgent need for the money as the petitioner
Money.
amount.
Everybody is in need of money.
As the petitioner number 1's father was hospitalized and it's a very critical condition. And petitioner...
Where from will the money come?
As the petitioner number 1's father deposited some amount in the Reserve Bank of India as the...
How can the father deposit in the Reserve Bank? Can you deposit money in the Reserve Bank? You cannot. So how can the father deposit money in the Reserve Bank?
There was
no check up.
My lord, I have taken 26 lakh rupees for a private financial institution.
You have
taken a loan.
Loan.
For 26 rupees. But I have already paid 2 crore 31 lakh. But keeping me in that, they have proceeded for auction my property on 29th October.
Yes.
And the matter was reached on the vacation bench, but it was not reached. So, my lord, if you kindly fix the matter for Monday.
Which bank?
BBA, a private financial institution.
Private financial institution and the writ petition is being moved. Very well. 28th, serve notice.
Yes, my lord.
May I be permitted to mention?
as application, Your Lordship.
1 minute. Yes, madam.
May I be permitted to mention? My lord, the petition in this matter, daily list item number 242, my lord. I am praying for upgradation.
Why?
The petitioner has been applied for an appointment of female candidates as health worker under ASHA scheme by a notification that has been published by respondent number 1. In spite of being selected, she was illegally not given the appointment.
Asha,
Yes,
go
Asha.
before the group 5 bench. Why over here? Yes.
Tenant matter, my lord, it's a very urgent tenant matter moved before the vacation bench on 16, my lord, but the list cannot be reached. It was in the list, but it cannot be reached. My lord, the financial bid can be opened at any point of time. My lord, there is extreme emergency. My lord, can it be?
Who is the tender inviting authority?
My lord, the West Bengal, my Mineral Development and Trading Corporation.
Very well. Tuesday it will appear. Serve notice. Yes, sir.
That this was moved during the vacation bench, but it could not be taken up. Matter relates to my lord. I have given a letter for
Let
repayment.
it remain.
My lord, I have given a letter for
Is it
repayment.
there in the
It
list?
is not there in the list.
Give the number. Combined list it will
lord,
appear.
the urgency that
Combined list.
I want to pay back the entire money.
So what? Pay.
My lord, they are not accepting.
What can be done? Time is over. SARFAESI
My lord,
notice has been
notice
issued.
has not been issued. That is
Maybe
the,
there
that is
must
the
be
pro-
some problem.
My lord, at least let it appear in the list, my lord, on Tuesday.
All right, Tuesday. Serve notice.
Your Lordship,
It has been
may I?
listed in this court daily list.
I'll
my lord.
release it.
Then my lord,
Your
Which item is it?
242.
240?
242.
242. Monday it will appear under the heading to be mentioned.
Your Lordship, as it was invested in the Bank of Baroda, it was mistakenly, I was saying that. It was
The
invested
bank.
in the Bank of Baroda and petitioner's father was hospitalized and it's a very critical condition. So it was urgent need for the petitioner as petitioner was request to the bank, but however, the bank is not cooperating with her request.
Yes.
So it was
What can
urgent,
be done?
it was urgent need for the hearing for recovery of that sum.
So the bank can release the money.
3rd of November it will appear. All right.
Your Lordship,
Give the number.
grateful, Your Lordship.
Yes, madam.
Your Lordship, I'm seeking inclusion for under the heading application.
Give.
Obliged.
Yes.
Your Lordship, kindly to mention a matter for upgradation, Your Lordship. In this matter, the petitioners were allotted a flat in a low income group scheme
By whom?
by the Asansol Durable Development Authority.
Yes.
Your Lordship, the consideration has been paid. The flats are ready, and they have multiple flats have been allotted and handed over to the allottees.
But then if it is a corporation matter, why are you coming over here? Go before the corporation bench. Yes, please.
May I have your lordship's leave to mention, my lord, 2023 writ petition, my lord, for inclusion. My lord,
What? Under the
inclusion, your
heading?
lordship.
Heading.
My lord, under the heading, my lord, new motion. My lord,
20.
I have mentioned this matter before. My lord, I've mentioned this matter. My lord, this is the matter where, my lord, I was an employee at an autonomous organization.
It's all right. Don't tell me the from 23 it states.
A very
it's the
nominal direction is required, my lord, for upon the, my lord, authority to consider my representation. This is what I'm praying for, my lord.
Give.
So grateful, my lord.
Serve notice.
I shall.
My lord, may I have your lordship's kind leave to mention, my lord, item number 1331 of the month list of September, my lord. My lord, what has happened, my lord? The National Commission for Scheduled Tribe has passed an eviction order against me. My lord, National Commission for Scheduled Tribe. Now, my lord, the police authorities are regularly visiting for vacating of the premises.
They are regularly visiting. Nothing
Uh,
done. Just wait.
So, my lord, there
Give the
is
list, please.
some urgency, my lord, already.
The issue is, Your Lordship, the respondent number 1 is the development authority. The respondent number 2 is a private organization, Your Lordship.
So
That's
what?
why
So
the
what?
matter-
Yes.
My lord, I appear for the petitioner. My lord, I am challenging, my lord, a decision of the, my lord, respondent authority in refusing to grant, my lord, subsidy. I am a, my lord, tea manufacturer. My lord, there was a scheme floated by the, my lord, union. My lord, in terms of that scheme, my lord, on the basis of my production, I was entitled to, my lord, ₹3 per kg as a subsidy. My lord, there are two, my lord, tea gardens involved in this writ petition, which is one is Norkhoi and one is Decom. My lord, I had, my lord, applied under the scheme. My application was in order. It was, my lord, taken into consideration. Application was registered, payments made and payments received by the authority. Thereafter, my lord, there was some issue. my lord, at the authorities end, they say, my lord, because of a transition from physical form to, my lord, the internet, my lord, they were basically shifting it to, my lord, digital form. So there were some issues they were facing. As a result, my lord, my application was, my lord, misplaced. Their contention is I should have raised a help desk ticket because of this issue. But in the impugned communication, the only ground on which they have rejected is that in the meantime, the scheme has expired and there is no, my lord, fund available for disbursement. This is the ground on which, my lord, they have rejected. My lord, kindly comes to, my lord, the impugned communication first, and then I'll take your lordship through, my lord, two provisions of the scheme. My lord, the impugned communication is at page 191, my lord, volume 2.
Yes.
This has reference to your letter of 25th November 22 on the subject cited above. It may kindly be noted that the board has adopted online system of processing of application of subsidy. It would be evident from the letter dated 25th November 22 that both the gardens have submitted its application for which specific file number was created. So, my lord, they admit that the application was submitted, file number was also created. But no acknowledgement was issued as because confirmation of transaction are pending in respect of bank's end. My lord, I'll show from the documents disclosed in the writ petition that there was nothing, my lord, pending from the bank's end. Your client, instead of raising help desk tickets, chose to file application afresh, for which the whole application got inactive and could not be processed further. In the meantime, other applicants who applied successfully, including subsequent application of your client, were processed and subsidy was disbursed. And in the meantime, the plan period for the disbursement of subsidy expired on 30th September 21, and no further action could have been taken by T-Board. Since the planned period is over and the board has exhausted the amount granted by central government for payment of subsidy, there is no scope for revival of the impugned application and payment of subsidy thereof by processing the said applications. My lord, kindly comes to the scheme, my lord, which starts at page 24, my lord, volume 1.
Page 191.
Yes, my lord.
Second paragraph you just read. In the meantime, other applicants who applied successfully, including subsequent application if your client were processed.
My lord, the scheme envisages applications for, my lord, half-yearly period. So, my lord, it is for the
Next period or the next term
half-yearly
possibly.
period. Yes, so this was, my lord, the particular applications which is the subject matter of the present writ petition. This was for a period prior to the subsequent applications.
Alright.
So there is only a 6-month period for which I did not receive subsidy.
What happened to your subsequent
I
application?
received, my lord.
You received
I
it.
received subsidies, my lord,
Alright.
for the subsequent applications.
Alright.
My contention before your lordship would be that the procedure envisaged under the scheme is once an application is received, my right or my entitlement to receive the subsidy kicks in. My lord, whether you sanction it or not, whether there is any dispute at your end with regard to acknowledgement slip, my lord, tea manufacturer is not concerned with all that.
But
Because
then the tea manufacturer should be concerned with regard to the corpus that is over there.
my lord, I will show, my lord, this had fallen for consideration in a similar situation in respect of this tea subsidy scheme, where, my lord, the issue raised by union was that the corpus is not available.
Yes.
There, my lord, the court, my lord, came to the conclusion that if on the date of the application, if the application is otherwise in order as per the terms of the scheme, and if you were entitled on that day to the subsidy, merely because there is no budget allocation or the scheme has expired or the, my lord, available budget was allocated to other, my lord, tea manufacturers and therefore fund cannot be disbursed, my lord, that cannot be taken as a ground.
Where from will the money come?
My lord,
You have to think it over and you have to come up with a plausible explanation as
my
to
lord, that
where
is for
from
the,
the money
my lord,
will
that is,
come.
my lord, it is, my lord, a budgetary allocation made by the central government.
Right. Now the budget.
If the action is arbitrary, my lord, the central government has to, my lord, make allocation for that fund. That is my
budget allocation
contention.
from some other.
My lord, this, my lord, allocation which was there, which I was entitled to, I have been denied because of an arbitrary action. If lordship is otherwise with me on the, my lord, action of the government being arbitrary, then possibly, my lord, the second question comes, how will the money come? My lord,
No,
let me
no.
first.
If I go to that extent that yes, it was arbitrary, then I have to come to an opinion as to where from the money is going to come.
Yes.
Because their contention is that there is no money, no fund
There is no fund under that scheme.
under that scheme.
Yes.
Right. So that has also that is also playing in my mind as to where from I have to
My lord, then kindly
arrange
visualize.
money.
I understand this is a very logical, my lord, question, my lord, which lordship is putting me, because if it has to be implemented, how it can be implemented? My lord, kindly visualize the situation. I am only a single tea manufacturer. There may have been situations like this with other manufacturers whose applications were otherwise in order and who were otherwise entitled to the subsidy. Union, my lord, possibly, or tea board, my lord, cannot possibly say today that just because there is no fund, my decision of not giving you subsidy that day, though it is arbitrary, I cannot be compelled to pay today because there is no allocation of fund today. My lord, otherwise, my lord, this is basically giving a premium to the my lord, arbitrary action of the government or the, my lord, authority in not disbursing subsidy despite, my lord, a manufacturer being otherwise entitled to a subsidy under the scheme. So, my lord, it is
Despite you getting one of the portions, in one portion of the subsidy you got.
yes.
Thereafter,
My lord,
you
I
say
got
that the
all
action
portions
was
of the subsidy.
arbitrary.
My lord, I got all portions of the subsidy under
But
the
one.
scheme, but one, my lord, which is for a half-yearly period. My lord,
Right.
kindly comes to the scheme once, which starts at page 24. I will trouble your lordship with only 3-4 provisions of the scheme. My lord, page 24, my lord, the scheme is, my lord, titled as Tea Development and Promotion Scheme for Medium Term Framework. My lord, the period is 29 December 17 to 31st March 2020. This is the period for the scheme. Kindly comes to 25. The second paragraph. The date of commencement of
the page.
I'm sorry, my lord.
Which
Page 25, my lord.
20?
First volume, my lord. First volume.
Page 25, yes.
First, my lord, lordship comes back to 24. I'm sorry, I did not know.
Yes, 24.
Page 24, my lord, the scheme is titled as Tea Development and Promotion Scheme for Medium Term Framework. Period is 29 December 2017 to 31st March 2020.
Yes.
Kindly comes to 25. First paragraph. The date of commencement of the scheme is on 29 December 17. The date of duration of the scheme will be from 29 December 17 to 31st March 2020.
Yes.
Now, my lord, after this kindly comes to page 69.
Yes.
This is clause 2.2 of the scheme. This is regarding the eligibility. 2.2a. All orthodox tea or kind of orthodox tea like and green tea producers owning tea factories within India and holding valid registration under so and so in case of individual small tea growers are eligible for availing subsidy under the scheme. Then, my lord, duration, again clause B, my lord, the period is mentioned. C is admissible rate of incentive, subsidy at uniform rate of ₹3 per kg of actual production for both leaf and dusk grades. Then, my lord, E is, my lord, the procedure for payment of subsidy. The payment of subsidy of orthodox tea will be regulated on the following basis. Applicants may submit their application to the nearest field office of tea board for physical verification of the factory and manufacturing records. The claim for the first half-yearly production, that is January to June, must be submitted to the field office of tea board latest by 31st August of the year under application. Similarly, I am, my lord, with coming under the second category because it was, my lord, the second part. Similarly, for the second half-yearly production, July to December, the claim should be submitted to tea board latest by 28-29 February of the following calendar year. In case the cutoff date of receipt of application falls on board's holiday, next working day will be considered to be the cutoff date. Claims for July to December 2019 are to be submitted latest by 31st.
It is all right. But you only address with regard to the grounds on which it has been rejected.
Yes, my lord, kindly one more page, my lord, page 70.
Yes.
My lord, this is again part of, my lord, that clause E. What is important is, my lord, B. All applications shall be accompanied with a non-refundable application fee of 5,000. Fee is to be remitted directly by the applicant through electronic transfer to respective bank account of the tea board, and the transaction receipt is to be attached with the application depicting the UTR number and transaction ID. Application fee to be paid by small tea growers would be rupees so and so. Now, my lord, kindly comes to the relevant documents in respect of both the, my lord, tea gardens. My lord, this should be possibly in 139 volume 2 হবে না? My lord, page 139. This is part of volume 2, first page of volume 2, my lord.
Yes.
My lord, these documents from 139 to 143, which I will now, my lord, show, these are in respect of the first tea garden, which is Decom Tea Estate. Lordship will find the name, factory name at the top, my lord, at page 139. There's a table, my lord, there's a entry factory name, Decom Tea Estate. And the company name, who is the petitioner, who owns both these tea gardens, is Russell Tea Limited. Now, my lord, just after the table, my lord, Lordship will find details of the application. My lord, kindly comes to the sixth entry, period applied for, on the left. Lordship has found that.
Yes.
Yes, period applied for. Lordship says 2018, July to December. So this was for July to December 2018. And date of application is 16th February 2019. My lord, I had read the clause of the scheme. I was required to make it by 28th or 29th of February 29 of the next year. So which I made. Now, my lord, kindly takes the next, my lord, table, which starts with, my lord, the entry orthodox tea other than Darjeeling tea in kgs. Lordship has found that. My lord, that entry, Lordship will see, is the quantity mentioned 7,30,680.
There is no issue with that.
Yes.
The ground for rejection is something else.
My lord, the only ground for rejection is that no help desk ticket was raised.
Right.
And I will show, my lord, from their communication, their officers' communication.
There is no acknowledgement which was issued on because of the confirmation of transaction was pending at the bank's end.
My lord, kindly comes to one document just to address Lordship's query on this aspect. Kindly comes to 154. One communication from the, my lord, T-Board's officer. 31st of December 2021 email at the foot of that page.
Yes.
On, my lord, kindly marks the mail date 31st December, written by Joydeep Shahu.
Yes.
We have checked and found that both applications were received and submitted from two different IDs, details of where shared below. My lord, one is for, my lord, Decom, one is for, my lord, Knockroy. Regards, Joydeep. So acknowledgement ID is also there. They also admit that the applications were received from two different IDs of the two different tea gardens.
They means who?
My lord, this is, my lord, from the officer of T-Board, the respondent authority. In the affidavit in opposition, they have taken a point that this is issued by the officer from his personal email ID.
Right.
Now,
show me something from page 154 that the T-Board is acknowledging your application.
my lord, the gentleman Joydeep Shahu is an officer of T-Board. He not only, my lord, communicated with me, my lord, there are emails which were also marked to his senior who was the director of the T-Board. From the same email ID, this personal email ID, including, my lord, the director's email ID, which was again, my lord, with the domain name gmail.com. Not, my lord, T-Board's.
I do not know. There should be something. If they this is what you say. I do not know what is there in the opposition, but you say that they have refuted 154.
My lord, kindly
Show
comes to 155. Kindly comes to 155. This is again an email, my lord, just after, my lord, 154, another email of February 2022, again from Joydeep Shahu. Lordship marks the mail address again the same as in 154. Now, copy has been marked, apart from Amit Kumar, who is my lord, officer, copy has been, it has been CC'd to a gentleman called S. Sondarajan. Lordship will find that name, CC2. At page 155.
154, 55, CC is NK Khurana.
Then Sunil Singh,
yes.
and then S. Sondarajan.
Right.
Now, my lord, kindly takes my affidavit in reply.
Hmm.
Side by side, if your lordship takes affidavit in reply, page 10, which is the only annexure, my lord, in the reply. My lord, S. Sondarajan is the director of tea development. And kindly sees, my lord, the email address, my lord, of S. Sondarajan again.
No. This will not suffice. This will not suffice.
My lord, as a tea producer, I don't have any other document to, my lord, justify.
But you must be making official communications. There must be a receipt from their end.
Official communications after, my lord, the applications were filed.
Obviously,
But
acknowledging your application. Because this is what they say, that your application was not acknowledged. Show me the acknowledgement.
My lord, that's the reason why I was, my lord, referring to the application at 139, and I was referring to, my lord, the payments made, my lord, with regard to this application. Kindly, if lordship comes back once, my lord, at 139.
No, 139 is all right.
So 139, my lord, the amount which I am claiming is on the basis of 7,30,000 kgs of tea manufactured by this tea garden, and the amount is 21,92,000. Now this amount I get this amount from the inspection report of, my lord, the authority, which is at page 142. My lord, kindly comes to 142. This is the inspection report of Orthodox Tea Producing Factory.
Yes.
My lord, at the foot of that page, lordship will see the claim period is mentioned for July 18 to December 18. Total quantity is, my lord, 7,30,608. And it is being certified at 143 by the superintending manager of, my lord, the tea garden, based on which this certificate I have made this application and made payment of the sum of rupees 5,000, which is the application fee. I am not required to do anything else under the scheme, my lord, apart from making this application in order with this certificate and with the payment slip. And I will show, my lord, from their document regarding this acknowledgement also.
Yes, show me.
My lord, kindly comes to page 151. This is, of course, my email. Paragraph 1. Application for orthodox subsidy for the period July to December 18 was filed by Decom Tea Estate on the EGIX portal on 16th February 19. The application reference and file ID number is given. Transaction
Which
reference.
page? Which page?
My lord, 151.
151. Yes. 151.
Para 1, my lord. Point 1. Application for orthodox subsidy for the period July to December 18 was filed by Decom Tea Estate on the EGIX portal on so-and-so. Application reference file ID number.
Which letter is this?
This is, my lord, issued by us, the officer of the petitioner, addressed to, my lord, my lord, Tea Board. The address is, my lord, support.tb@government.gov.in. This is not to any personal ID. My lord, we are, my lord, giving it to the support team of Tea Board with the details of the application reference and the file ID with regard to Decom Tea Estate. Transaction reference number is also given. The payment gateway transaction reference number with the proof of payment of 5,000 rupees is given. Then further Decom's, para 2, further Decom's orthodox subsidy application for subsequent period was submitted on 20th August, copy attached. Going closely through the application, we found that the file ID assigned is this, which is same as assigned earlier for the claim period July to December 18. File number ID is system auto-generated, and as per our understanding, technically same ID cannot be assigned for two different periods. So what they had done was, my lord, the Tea Board, they had, my lord, assigned a file ID for the claim period July to December 2018. Same file ID was assigned for the claim period January to, my lord, June 2019.
Yes.
So this is what we point out. Also, the file extension for the claim period January to June 19 should have been June 19. Instead, it shows July to December 19. This clearly shows some technical problem with the EGIX portal that existed, and probably while uploading the application for the claim period so-and-so, it had overwritten our earlier application for the claim period July to December 19.
Now, the January to June 19.
I have received.
You have received.
I have received. So, my lord, there were some technical issues at their end. My lord, because of the transition that was happening from physical form to digital form. Now, for that, my lord, though my application was found to be in order, even in the impugned communication, they say that it was in order. My lord, though they have received, my lord, the payment of 5,000 rupees, which I was required to make under the scheme. My lord, I just did not get the, my lord, claim of subsidy for this period in respect of these two tea gardens because of this, my lord, discrepancy at their end. Now, the only contention in the affidavit in opposition, twofold contention. One is, my lord, Joydeep Sahu, who had, my lord, written that email of 31st December, because that contains an admission, they try to say or justify that Joydeep Sahu was not addressing from the official email address, he was addressing from a personal email ID. My lord, to deal with that contention, I was referring to the affidavit in reply, because Joydeep Sahu was also, my lord, marking copies to Mr. Soundarajan, who was the director of the, my lord, Tea Board. It is not that I was, my lord, trying to get some benefit from an officer of T board with regard to my application. I had come very clean with my application and it is in order. My lord, if lordship kindly takes the opposition once, 2 paragraphs I want to show from the opposition. My lord, kindly comes to internal page 6. Internal page 6, my lord, subpara I of paragraph 4. In the case of Knockroy and DCOM, the application for orthodox subsidy could not be submitted by the applicant within the stipulated time frame. My lord, I dispute this, my lord, contention, because I showed from the application that it was within the stipulated time. As a, my lord, producer, I have nothing else to do but to, my lord, upload the documents with the details. And it was within that time. By the time the applications of the petitioners were successfully submitted, it is because of their technical issue, they say the successful submission is post the date of 29 February. In the portal, much beyond period, the communications at Annexure P6 of the petition are inconsequential to the applications initially submitted by the petitioner, as the scheme under MTF period ended on 31st March 21. But there was an extension of the scheme from the original date. It is needless to mention that the email cited by the petitioner at Annexure P6 are subsequent to the date of the expiry of the scheme. It is to be mentioned that in order to address any issue related to online application, the applicant needs to raise a ticket in help desk on the portal itself. However, it is observed that there is no such type of communication that was made by the applicant regarding the issue problem faced by them through the online portal. My lord, pausing here for a moment, whenever, my lord, we are also shifting from, my lord, physical form to digital form every day. Whenever we face, my lord, difficulties, we have, my lord, your lordship sitting here, my lord, for a leave, my lord, to resolve this issue. My lord, here in the portal, their contention is you could have only raised a help desk ticket and wait for the fate of your application. My lord, assuming for a moment, my lord, hypothetically, my lord, I raise a help desk ticket, but the claim period is over or the scheme period is over. My lord, they would have then again taken the same contention that no, this has not been resolved, so you're not entitled to, my lord, the subsidy under the scheme. My lord, this, according to me, is, my lord, arbitrary discrimination between 2 sets of tea producers, both of whom may be entitled to the, my lord, subsidy under the scheme if their applications are otherwise in order. Further perusal of Annexure P6 would reveal that the communication was between 2 private individuals with no relation, knowledge, or information to T-board. Such emails not binding on the answering respondent under any circumstances. Sri Joydeep Sahu, to whom email was sent, had no authority to write such email. Well, this is only because the gentleman, the officer, had admitted that these 2 applications were received and file numbers are also mentioned in that email. So this is how they try to come out of that email. Sri Joydeep Sahu, to whom email was sent, had no authority to write such emails as enclosed in Annexure P8 of the petition. The board is in the process of inquiring into the details of such email. The board does not vouch the contents of the email as enclosed in Annexure P8. Board does not vouch the contents of the email. As per the scheme guidelines, liability of board arises once sanction letter is issued by the board. Well, I'll rely on one judgment only to establish that sanction is something else. But if you wait for eternity to give me a sanction despite my application being in order, you cannot deny me subsidy only on that ground, because that is completely within your domain. You can't discriminate between 2 producers of tea only by reason of, my lord, a sanction being, my lord, issued later. Because according to me, my right to receive subsidy vested when my application was in order and it was received by T-board. In absence of sanction letter, liability of the board does not arise. So this is, my lord, their second contention. They rely on a coordinate bench decision of our High Court. My lord, kindly comes to this, my lord. They have annexed it, my lord. Kindly comes to page 21.
We'll look at the decision on the next day.
Very well, my lord.
Please come.
It is also covered by your lordship's decision. Ringtone. Judgment on ringtone will not clearly cover this.
I'll also consider that and come back, man.
Yes. And will not submission of application will not does not will not clause. My London will not did not.
Next day.
Yes.
Learned advocate for the petitioner's comments argument, but does not conclude the same. Stop. List for further hearing. When?
Next Friday.
Friday?
Friday.
My learned friend wants next Friday. I am
31st? Next Friday? All right. Next Friday. 31st.
my lord 31st. I'm sorry, my lord. I won't be in town, my lord. Maybe on my lord in that case 30th, my lord. If that is
It's a holiday, my dear.
oh, sorry. My lord, I'm sorry, my lord. My lord, in that case, my lord, the week next, or I can come back next Monday, 27th, if lordship permits me.
No, 27.
Then, my lord, monthly list starts on Thursday, third, then
Third or fourth.
fourth, my lord, fourth I can come.
Motion pressure will be too much. I'll
Friday
be
week, my lord,
preferring
in that
a
This is an
Friday.
original site matter, my lord.
Yes.
Make it on Friday week, my lord.
Friday week? 7th?
Yes, 7th.
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 Deal.
Motion
Today.
I take this opportunity to wish your lordship, my lord, Shubha Vijay. my lord.
Shubha Vijay. To everybody.
Grateful, my lord.
Lordship, I am for the petitioner. Lordship, what happened this matter? Petitioner submitted deed for registration, Lordship.
Who is your other side?
Lordship, actually, okay, Arjun. Point what judge?
Where is he?
Lordship, last 2-3 occasions when the matter was taken up,
He did not come.
Lordship, I am suffering, Lordship.
Has he come today?
I don't know, Lordship.
Check up.
Lordship, one thing, Lordship, I don't insist your Lordship to take up this matter in absence of your Lordship. Can you take up this matter Monday, Lordship?
Yes.
Even it's on in the same position. But because
It will remain in
lowered
the same
down, Lordship, and that
position. It will remain. Bring your other side. Matter will be taken up.
Monday ছুটি নাকি? না না কিছু না। Monday, Lordship. Lordship has stated generally, Shubha Vijaya, Shubha Vijaya.
Shubha Vijaya. Shubha Vijaya.
Matter.
Lord,
It is
I'm
the
happy.
group 6 hearing matter. Well, if your lordship kindly takes the last order.
Lord, I am appearing for both institute in this matter.
When was it assigned?
Yes, my lord, probably it has been assigned to your lordship.
And I'll give your lordship the background.
24th of September.
To approach the Honorable Chief Justice for assignment of the matter before the appropriate bench having determination. So, my lord, it's a group 6 matter.
It has been assigned. I can see the Chief Justice's assignment before this bench. I do not have determination, but then this is the assignment.
My lordship is having heavy determination, my lord.
Yes, you do not want before this bench.
No, my lord, lordship.
I can release
It's a
it.
hearing matter, my lord. I'm afraid, my lord, my clients will. This is very
Yes.
unfortunate
Lordship
case for the
can-
petitioner. I'll give your lordship the background.
No, don't give the
Three
background. If
different
you are
benches, my lord.
interested, then
My lord,
please
matter has been
analyze
heard
this.
before 3 different benches. For some reason or the other, my lord, petitioner have concluded the hearing. Either, my lord, the determination change or something.
I am not aware of anything. I can see the very first page where the name of this bench is written. You say you do not want it. I'll release it.
I'm the last person to say this thing, my lord, before your lordship.
She may kindly fix the matter any day, my lord, subject to your lordship's kind convenience, we'll finish it up.
We'll finish it up.
My lord, what my lord?
3 different benches released it.
No, my lord, it
No,
was a
not really, my lord, it
continuing
was
matter.
heard.
Only, my lord, it could not be heard out, my lord, at length because, my lord, there was a change in determination. And, my lord, Mr. Shuvendu Samanta was hearing the matter.
Two honorable
Two
judges
matters, my
transferred.
lord, already
One honorable
passed
judge.
the order, his lordship.
Past order.
My lord, there were analogous
Final order
matter.
passed.
And 7 analogous matters were taken up.
Final
2
order
relates
passed.
to technical employees, my lord. Those were disposed of with directions, while the impugned order was set aside. My lord, we are for the administrative employee. My lord, the same impugned order is under challenge before your lordships.
What to do? I release it.
My lord, lordship may kindly fix it, my lord, in sometime, my lord, in the month of December.
My lord, meanwhile, you also, my
this
lord,
one, my
prefer
client
an
are
appeal, my lord, challenging, my lord, that order, my lord, passed by my lord, Mr. Samanto. So, my lord, in the meantime, my lord, some order may come, my lord. Then your lordship, my lord, will not be having any difficulty, my lord. My lord, sometime in the month of December, lordship kindly fixes.
The matter has been assigned before this bench by the Honorable Chief Justice within bracket acting on 24th September 2025. Stop. Learned advocate representing
My lord, Bose Institute.
the Bose Institute, comma, one of the respondents herein submits that an order passed under similar circumstances by a coordinate bench of this court has been carried in appeal, and the appeal is due to be heard shortly.
No, my lord, we
They
have
have not
not,
filed any
my
appeal.
lord, we are yet to file, my lord, the appeal, my lord.
Yet to file.
No appeal, Lord.
Then
My lord, we are preparing.
no.
3rd of September order was
এটা
passed.
তাহলে লেখা যাবে না।
My lord, there were three corrections made
September.
thereafter.
There were corrections. So that is why.
Then this cannot be.
But this week, my lord, next
Not
week, my lord,
better.
we'll file the appeal, my lord.
But
My
First of
lordship kindly
September.
fixes, my lord, any day, my lord,
First of-
subject to lordship's kind convenience.
Next Friday I keep it. You
My lord,
check up
yes, by that time it will be filed, my lord. My lord.
লিস্ট করুন তো ওই 24শে সেপ্টেম্বর অ্যাসাইন হয়েছে ওই অবধি রাখুন, তারপর লিখুন released on 31st of October. Parties shall come ready.
Grateful, man.
In the meantime, you check up facts and everything.
My lord,
All
facts are
parties,
same, my lord. Facts are same, my lord.
whether the
administrative-
same order is under appeal or
Well,
not,
same
similar order.
of October 2019 is the impugned order. Well, that relates to the technical employee as well as administrative employees. Well, the order covers the technical employees. Well, we are the bunch of administrative employees before your lordship.
Whatever, please check up.
I shall, your lordship.
Grateful.
So grateful, my lord.
Item number 2, my lord, I am appealing petitioner. I am appealing for the state, my lord. I am led by Mr. Bosumoldik. He is appealing.
Yes.
appealing virtually, lordship.
Yes.
My lord, your lordship, there is some urgency in this matter, my lord. Petitioner, my lord,
Motion or hearing?
motion, they have filed their report.
Three
report has been filed by us.
All right.
Different.
Yes.
My lord, may I place the matter?
Hmm.
My lord, in a nutshell, my lord, the facts is, my lord, your petitioner is a government hospital doctor. My lord, for pursuing post-graduation, MD, Masters, my lord, she participated in NEET. She obtained a rank. My lord, thereafter, she applied. The rule is, if you are an in-service doctor, you have to avail the in-service quota. For that, a trainee reserve form has to be issued. Petitioner applied. Before that, the issuing authority gave no objection that petition is eligible for TR and he may apply for TR. My lord, petitioner applied for TR. According to that, petitioner was given a college in Shishu Mongol. Petitioner got admission in Shishu Mongol, was in counseling, my lord. Thereafter, my lord, the respondent authorities issued a list of persons that total number of 333 TRs were issued. The rule is, my lord, according to their circular, 10% of the existing strength TR will be issued. Suppose
strength of
total persons serving in the health department.
all right.
existing strength.
All right.
My lord, we have challenged firstly that this existing strength is coming to more than 333. Why? For the last 6-7 years, there has been no new recruitment. 2 previous year, it was more than 400. Even this year only, this 25-26, it is 389. Only last year, it is 333. So we say it is arbitrary. It should be more than this, firstly. Secondly, my lord, the rule only says 10%. What they have bifurcated it, those 333, my lord, into 3. My lord, this health service comes into 3 categories: doctors, administrative, and my lord, health service. My lord, they have health and education service. My lord, one is doctors. For doctors, they have given a certain percentage. Doctors and health, they have given a certain percentage, and for education, they have given a certain percentage. We say you cannot bifurcate. According to merit, you have to give the base 333 the tier. They have again done so. My lord, according to their report, they say they have issued On record, they are saying 333, but on papers I have submitted, my lord, a spiral which shows they have issued 355 trainee reserve. So if they have issued 355 trainee reserve, then why am I being left out? This is the, my lord, facts of the case.
What is the report they have filed?
My lord, report they have filed is, they have bifurcated the 333 into
This bifurcation is there in the report.
in the report, and according to their report, my lord, they have only stated that they have bifurcated it and 333 is the total number.
All
My lord,
right.
if 333
And there must be a commencement date of this training period. Now that period.
No,
Over.
no, I tell your lordship, I have been given admission in
Yes.
now within December.
Yes.
Within December, if your lordship is in my favor,
Right.
I will be allowed to get registered in the West Bengal University of Health Sciences, and I will be allowed to pursue my classes. Only difficulty will be if the I might be allowed to give a supplementary examination, because there is a
When did the course commence?
in August.
We are already
But I have been
end of
given
October.
admission. Man, I have been given admission.
But then you could not attend classes.
My lord, I could not because I have not been registered. That is why, my lord, provision is there, my lord. Now, difficulty is, suppose, my lord, I am not being able to get admission here. For no fault of mine, for next 2 years, I cannot participate in NEET PG.
Why?
Because I have wasted a medical seat.
You have not wasted. It
That
is
is the law, my lord. I can show your lordship.
But then it is not you wasting in the seat because you are interested to join. It is the authority not permitting you to join.
Ultimately, I do not succeed, my lord. That has to be clarified by your lordship. Otherwise, my lord, this NEET PG is also going on. Counseling, I will not be allowed to participate. If I do not succeed, my lord, then kindly clarify that.
Mr. Basamalik?
Now, the report which we have filed, my lord, that we have segregated, that has been minuted, and that has, in the earlier court, my lord, that has been accepted that. And what we have done it, my lord, the 3 categories, my lord, if we give all the doctors these facilities, then the persons, my lord, who has not treated as a doctor, but they are my lord, acted as a my lord, professor and all, my lord, they will be sufferer. So that's what, my lord, we have segregated. And these petitioners has not come within that zone of consideration with regard to their doctors. That is the reason.
Petitioners are not doctors, they are doctorates or what?
They are doctors. Now,
They're
my lord, these are
doctors.
the three categories we have segregated. So for this net PG, so for this trainee reserve is concerned, my lord. So for these doctors are concerned, that is up to 1,70,000. We have my lord, decided to give 1 lakh up to 1,70,000. But these 2 persons has not come within their zone of consideration. That we
What
have
is their rank?
their rank is
1,72,000
177 and 2 plus something, 2 lakhs, and one is 1,80,000 and odd, my lord.
All right.
So that is
Now-
that we have explained in our report, lordship.
All right. Now tell me, the petitioner is apprehensive that if they are not permitted to start their course, they will not be allowed to sit in
No,
the.
they have not come within the zone of consideration. There is no question of start of course. The course has already been commenced. The persons has already been selected, and those who have started their training. And
Right.
now,
So
what has
next
happened, my lord,
year, when the
next year.
examination NEET PG is conducted, the petitioners will be entitled to
Yes,
participate.
they will because last time I had a talk with the department also, my lord. If lordship so desire, lordship kindly fix this matter any day. I will come up with the specific instruction whether they will be eligible for the next year trainee reserve or not. I will come back, your lordship, my lord.
What about trainee
Entire
reserve?
report I have filed, my lord.
My lord, kindly come to
If
page
his
7.
lordship allowed them to join, my lord, then entire situation will be changed, my lord.
My lord, if their case is 333 tiers they have issued, according to their report. But on record, my lord, I have submitted, they have issued 355 tiers. How are they getting? If the rule is 10% of the total existing strength, then it has to be 10%.
Where is the existing strength disclosed?
Yes, my lord. No, that is the, my lord, fallacy. Nowhere it has been declared what is
No,
the
we have declared 333. That we have been done. But after that, they say 345, 355. But we are stick on 333.
Your lordship,
According to that, my lord,
page
yes,
100.
we have done it.
My lord, page 100, your lordship kindly comes.
Page 100.
My lord, may I read paragraph 2?
Hmm.
In view of the above, after careful consideration, the governor is pleased to pass an order for fixation of permissible limit of postgraduate tier every year academic session for the officers of the above mentioned services in suppression of all other. My lord, henceforth strength of trainee reserve will be fixed at 10%.
Of the existing strength, not sanctioned strength. What is
sanctioned.
the existing strength?
My lord, suppose if the existing strength is 1000.
No, did they disclose the figure?
No, my lord.
No, we have disclosed 333 million. How is there no million? We have filed 2 reports.
But
Assuming if 333 is 10%, then you can calculate. Yes, 3,300 is the figure.
Now I say, then 3,300, 10% is 333. Take it.
Right.
Then they have issued 355 years. That is evident from the, my lord, the documents I have submitted in way of a spiral binding.
Yes.
My lord, kindly see the number in the very first pages. It is number of tiers issued has been given. My lord, if your lordship kindly comes from page 1 onwards.
Page 1.
My lord, kindly see second line 40.
Second line 40.
This is the number of tiers issued first.
Yes.
Candidates. And their details are also given, my lord. Thereafter, my lord, page 7.
You add up.
Yes, I added up. It comes to, my lord,
355.
355. Now, if 355, now your lordship kindly comes to page 5 of their report.
Yes.
1. Why I am saying this is, my lord, kindly come to page 5 of their report. At Roman 7.
Yes.
My lord, kindly see how they have stated that how this 333, I am reading. I say that in exercise of the powers conferred under Rule 9 of Tier Rules 2015, a meeting was held in order to distribute the total number of declared tiers amongst the different cadres of the Department of Health and Family Welfare. My lord, I am skipping thereafter on Atho. And the resolution was passed wherein it was categorically declared that there should be a percentage of seats which may be reserved for WBMES. WBMES, my lord, education service. This is one cadre. And the House unanimous decided that 12% of 333 should be reserved for WBMES. Now, my lord, 12% of 333 comes to around 40.
We are not going to 12. Here also they stick to 333.
333.
Say it's 355.
355. Then, my lord, why I am here? If 355 is taken, then it's 355, 12% of 355 should be reserved for education service and the rest for doctors and administrative.
Why are you increasing 333 to 355?
Because they have increased, my lord. I have not increased.
No, they say it is 333 only.
Paper, my lord, it is a wrong statement on affidavit, my lord. They let them say that they have not issued these 355 tiers. I have issued the date and their documents I have given in the form of a spiral binding.
Mr. Basamalik.
Lordship.
Your contention is that only 333 trainee reserved seats were allowed.
Has been allotted to the different categories of the doctors.
All right. Now, according to the petitioner, the seat is 355.
According to them, my lord. But I have no
No,
instruction
they have
with regard
given
to
documents also. Not that.
Now, my lord, this is what they have done it, my lord. This is calculations of medical services and the others, my lord. Not all. They are not all the doctors. And the problem is, my lord, up to a certain limit we have fixed for the doctors. But they have not come within that zone. Now they have said, my lord, that they have to giving the trainee reserve and all. So that is the whole problem in this matter.
There is a problem with the calculation that you are saying.
I shall come back before his lordship, my lord, with a fresh calculations and what they have said. And I have definitely 2 reports has been filed by us. In both the reports, my lord, we have categorically said 333. And my lord,
333 is the combined strength. According to you.
No, this is the strength for that previous year. Now, my lord, this year it has been
Combined
increased.
strength for
It
that
depends.
previous.
It depends. My lord, not all the time. Now, this year, my lord,
No,
389.
for the concerned period for which the petitioners are contending,
333.
right?
But according to us,
333
333.
is the
Lordship.
combined strength for the medical and emergency services, the health services, the doctors,
Lordship.
and everybody.
Lordship.
333.
333, my lord. According to we have calculated and
Please come.
accordingly, my lord,
My lord, only one thing, on the last occasion, the officer was called by the then coordinate bench.
Right.
And the officer also said that they do not know how it is 355. They do not know how it is 355. Therefore, because of paucity of time, the honorable court released the matter. Your lordship, kindly say how is it
The
355?
Learned court released the matter for a different reason, my lord. Because
yes, not for any other reason.
the
matter
reason
could
was
not be taken
the
up.
reason was that this writ petition is not maintainable because, my lord, this is
That
related
is why
to a
we-
service condition and this is a judgment, my lord, on last
Yes,
of.
yes, but I forget that. But my junior is there. But the judgment is there. But absolutely on the point.
No, but then why is it a service condition?
Because, my lord, I'm stating, my lord, because these particular
They are in-service
they
candidates.
are in-service candidate.
But then this has got nothing to do with their service.
No, this is related to service because
Why?
this will
Any reserve, my lord? The can go through the judgment once, my lord. Absolutely on the point.
go through the judgment. It has the same.
Absolutely on the point, my lord. They have to go to the tribunal.
No, my lord, not at all. Kindly do not mislead.
Kindly see, my lord. Kindly
Which order date? Which order date is to be seen?
Yes, my lord.
Which order date are you referring to?
No, my lord, on last occasion, this judgment has been showed before the.
Where is it recorded? Has the court noted anything?
No, my lord, I don't think that was noted, my lord. The coordinate bench.
The petitioners may be in-service candidates.
Yes, my lord.
Right? But then this training has nothing to do with their service.
It is, my lord. Kindly.
Yes, my lord. It is service, my lord. It has enhanced their
Judgment,
qualifications.
my lord.
But kindly go through the judgment once, my lord. Kindly, my lord.
My lord, kindly once.
Kindly
This
go through the judgment once.
This judgment.
My lord, kindly go through once. They are similar issue, my lord.
Similar issue.
Here, my lord, whether it was entitlement to tier was there.
The administrative tribunal, is it functioning?
Oh, no.
It's still not
Not
functioning.
yet. Still not functioning, my lord.
It is not functioning. I am having matters. I am having matters before this bench where deduction is to be passed for.
Yes. I am
the
appearing
service
in that matter, my lord. I know,
Right.
my lord. His lordship is
So
appearing. I
the
know.
service tribunal is not functioning. Where is the alternative? So there is no alternative. Please come.
No. September.
The petition has been assigned before this bench by the Honorable Chief Justice within bracket acting on 24th of September 2025. Stop. The matter relates to appointment of trainee reserve for the session 2024-2025. The according to the petitioners, they are entitled to be appointed as trainee reserves. Stop. According to the respondents, the petitioners have not come within the zone of consideration, and the petitioners failed to come within the zone of consideration. Stop. The respondents have filed reports disclosing that there are only 333 seats.
My lord, may I interrupt one, my lord?
Within bracket, combined for all cadres. Stuff. The petitioners have filed certain documents in support of the submission that the authority appointed 355 candidates.
My lord, appointed, issued tier
Acha. Issued the trainee reserve. Document in favor of 355 candidates. Stop. The respondent authorities are directed to file a report clarifying the discrepancy. Stop. The report shall also disclose as to whether the petitioners will be permitted to appear in the NEET PG examination.
My lord, I can appear in NEET PG, but not in the counseling. NEET there is no bar.
Acha. Can appear for counseling. Appear for counseling with the same rank, or you are
Next NEET PG, I have already qualified the
next year also?
Yes, NEET PG.
And
Counseling will be very soon will be.
Acha. Tale likhun counseling in the subsequent NEET PG examination where the petitioners have qualified.
Counseling, my lord. It should be.
Yes, yes. Counseling under the NET PG where the petitioners have already qualified. How soon can you come back?
Fortnight time, maybe give me, I shall file.
Kindly expedite, my lord. If I
Sir,
succeed,
this is, my lord, kindly appreciate, my lord, from last 3-4 months, this
4th
matter has
of
been
November.
going.
4th November.
Yes, ma'am.
Take this
May I
back.
submit one thing, my lord? This writ petition was filed in June 2025.
Hmm.
At that time, SAT was functioning. But they did not approach to the SAT
My lord, I say
before
this is
filing
not
this
a
writ petition, my lord.
jurisdiction which
From
is
September, it is not functioning.
Get full.
It's not anything on behalf of the petitioner. When this matter was assigned by the Honorable Chief Justice, the matter was released by another court in the bench on the personal ground. One of the similar matter was passed by your lordship regarding the registration of e-rickshaw.
Right. Give.
Another similar order was passed.
Where is yes,
Mr.
it's the same.
Very grateful.
When these matters, my lord, were used to come up regularly, my lord, there was, my lord, several confusion, and my lord, then eventually, my lord, a way out
Has been found out.
has been found.
Are you aware of this order?
Yes, my lord. Same order.
Check up.
Oh, yes, I have gone through.
You've gone through. Same order can be passed. Any change of date or anything?
No. Only my lord, nothing.
No, nothing.
Nothing.
So far, the order that has been, my lord, handed over to your lordship, my lord, I think
It is 19570 of 25.
it is 1957025.
Same order to be passed. Please go through. In case there is any change, please let me know.
But my lord, I have gone through just now, and my lord, I think, my lord, there is, my lord, nothing.
This is in general, this order has been.
Yes, in general.
All right, same order.
Only thing that particular paragraph number 9 is the important paragraph.
Next one is also same. You are there?
Yes.
Yes, same order.
Get.
Shubhrata Babu, একটা line লিখে দেবেন. The matter has been assigned.
Yes.
Otherwise, later on it will be difficult as to why, how could this be taken up by this bench? assigned before this bench by the Honorable Chief Justice within bracket acting on such and such date.
Without মিষ্টি
এটা
তুমি
ওখানে দেখে
my
নেবো।
lord কে অভিজয় বলছো।
Yes.
Item number 106. Unfinished item number 106.
দেখি লিস্ট দেখি। You make it not today only. Not today. None appears for the petitioner. Released on 28th. Let notice be served upon the respondents. Yes.
219.
For the state respondents, my lord.
Yes. Petitioner is not here. What is the matter?
Madam, my lord, against the order of the my lord Chief Judicial Magistrate, the
take.
SARFAESI case, my lord, actually, it will be decided by the Debt Recovery Tribunal jurisdiction, my lord. Regarding against the finance, my lord, the borrower has come, my lord. Debt Recovery Tribunal is the my lord, original authority to adjudicate the matter.
Dismissed. Record your appearance.
Yes, ma'am. Get to know.
Item number 220.
Lordship, I appear for the respondents number 1 and 2.
Yes.
Lordship, I beg to appear on the petitioner.
Yes, please.
Lordship, SARFAESI proceeding, petitioner actually, Lordship, that paid for a considerable time, Lordship, and the installments also continue to pay, Lordship. But what is I'm disputing is that, Lordship, that during the moratorium period, Lordship, that is in the COVID period,
You've
there is
made the advocate a party over here. Why? Respondent number 6.
Lordship, he is the appointed by the learned additional chief judicial magistrate
Yes,
for
to act as
taking the
author.
possession. Yes, Lordship. He is the receiver kind of.
He should not be added as party. Anyway, now you are challenging what?
Lordship, that proceeding initiated by the bank, Lordship. Though there is a SARFAESI.
Which bank?
Lordship, 1 and 2
They-
private bank. Aadhar.
Aadhar.
This is a financial, non-banking financial organization. How is the writ petition maintainable?
Lordship, that the steps taken by the bank, if he's in the
No, this is a non-banking financial institution. Please come. The writ petition has been filed against a non-banking financial institution which cannot qualify under Article 12 of the Constitution. In view of the above, the writ petition is not entertained. Stop. The writ petition stands dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner to approach the competent forum for remedy in accordance with law if so advised.
SARFAESI is already pending, Lordship. That
Go there.
Item 221.
Good day. Dismissed. Dismissed.
Well, I appear for the state respondent.
Yes.
Thank you.
Dismissed.
Grateful to Lordship.
Alert in item number 222, Mr. Devashish Shah is appearing for State Bank of India and praying for an accommodation.
222 record an order. Accommodation sought for combined list. November. Immediately dismissed.
I beg to appear for the respondent bank, my lord.
All right, dismissed. Dismissed.
My lord, I am for the petition. I am praying for not today, my lord.
All right, accommodation sought. A November monthly list. Give your name. Yes. Dismissed.
I am for the petitioner. I am paying for not today.
All right, give your name. Third. List.
Lordship, in item number 229, I'm appearing for the respondent. I have not been served with a writ petition as of yet.
Which respondent are you appearing for?
It appears to be so, respondent number 9 and 10. Arcel.
Arcel.
Arcel. Asset Reconstruction Company, India Limited.
All right. Since the petitioner is not here, it is being dismissed for default.
Lordship, 222, I'm appearing for the state respondent.
222. What has happened? It has been adjourned. Third, it will appear.
I am for the petitioner. Same ground, ma'am. Not today. 28 or 23.
All right. Not today. All right. Accommodation sought. Third.
5 also not.
225 টা ডিসমিস হয়ে গেছিল, এটা কোন নট টুডে করে থার্ড করে দেবেন। Yes. 231 টা হয়ে গেল। Yes, yes.
232, I am appearing for the respondent Canara Bank in this matter.
Yes.
Well, this is the matter wherein they have challenged the action taken by the bank under SARFAESI Act. They have challenged the order, notice dated 4th of August pasted upon the bank. But in the meantime, borrower has already obtained a stay and injunction order from DRT1, which is still operative.
Show me that order. Anything is there?
My lord.
You give me the details, I can record and dispose it off.
My lord, the last order of 18th September. My lord gives me, I will hand it over to my.
All right.
Because
the
it is a
case details, the case. Are you sure it is in this matter?
Yes, my lord, 232, 234 and 235. These are the writ petitions filed by the present occupier of the premises, wherein in an earlier order was also passed by by this learned by my lord, wherein the DRT was directed.
Occupier, not the borrower.
No, and they have
and the petitioner over here. Occupier is the borrower.
No, borrower is the other.
Separate. Here it is filed.
And both all the matters they have, bank has, they have the borrower has obtained a term loan.
No. Is it your case that the petitioner has challenged the impugned action of the bank in two separate forum?
No.
Separate party is over here.
Separate parties. Here they have challenged the DRT one has passed an order that you have to give a 2 weeks notice for vacation. Bank had
Yes.
got a order from district magistrate for vacating the
That is
premises.
separate.
That is separate. Only on that order they had come before my lord.
Yes.
In between, the borrower has also filed an interlocutory application before the in the essay proceedings filed by the borrower, wherein DRT has already granted stay.
All right.
No physical possession will be taken till the disposal of the essay. So this becomes infractuation anyway.
Type of
I will order just now.
please, Ashwanta. Learned advocate representing Canara Bank submits upon instruction that the
My lord, for state.
235.
Wait, this is 232. That an application has been filed before the Debts Recovery Tribunal. Application securitization application filed before the Debts Recovery Tribunal by the borrower.
By the borrower.
And an order of stay has been passed on such and such date in such and such matter. ঠিক আছে? As the writ petition
35 of 2022.
Put it down in a piece of paper and hand it over.
Hand over the complete order.
All right. Acha. As the petitioner is not represented, the writ petition stands dismissed for default. Same order will go down in 234 and 235. Actor por actor ডাকবে, please wait. 233.
Great.
Lordship, I beg to affirm the petition.
Yes. Kotak Mahindra. It is the same thing. এর আগে কোনটা order হলো?
Lordship, there is some judgment of this coordinate bench of this honorable court, Lordship, that
yes,
if bank is performing some duties in the capacity
this is
of
not a bank,
but a financial institution, Lordship, performing certain duties under the statutory.
No, the Supreme Court judgment is against. You know it very well.
Grateful, Lordship.
Same order হবে. Does not qualify under Article 12. Yes. হয়ে গেল তো 234 same as 232 and 235 is also same as 232.
Please, Your Lordship, I'm appearing on behalf of the petitioner Bank Millet. Order has been passed under section 14 in the month of January 2025.
So your purpose is served?
Millet, it has been passed but not executed, Millet. That is my prayer.
Your writ petition is for execution?
Execution of that order.
Show me the order. Who is your other side?
Millet, we have served, Millet, but...
Show me the order, section 14 order.
Millet, it's at page... Millet, page 28, Millet. At page 29, the date of the order is there.
Yes, 18th of January 25.
Malo.
And it was to be enforced within 6 months.
We want enforcement of this order.
I can understand. Ashun দেখি. The petitioner, bank, seeks execution of the order dated 18th January 2025 passed by the District Magistrate Not 24 Parganas under section 14 of the SARFAESI Act. Stop. The order was to be enforced within 6 months from the date of receipt of the same. Stop. According to the bank, the district magistrate did not take steps for execution of the said order. Stop. Paragraph. As the Order under section 14 within bracket 1, not 1, section 14 has been passed by the competent authority. Accordingly, the said authority ought to take steps to ensure that the said order is enforced within the time as specified in the same stuff. The time period within which the order was to be enforced has elapsed in the meantime. Stuff. The district magistrate, not 24 Parganas, is directed to take immediate steps to enforce the order which was passed on 18th January 2025 by extending the validity period thereof. Stop. The district magistrate shall ensure that the said order is executed at the earliest, but positively within a period of 6 months from the date of communication of this order. Writ petition stands disposed. Service taken on record. Next one is also same.
In 237 talks of settlement is going on. I'll just pray before your lordship that it can be
All
given
right.
in the combined monthly list of
Right.
November.
Learned advocate for the petitioner submits that talks of settlement are going on. Stuff. Prayer has been made to post the matter in the monthly list of November 2025. Stuff. In view of such submission, list on 3rd November. Monthly list. Next.
Much obliged.
Dismissed. Dismissed. Dismissed.
Lordship,
নামটা দিল
240.
240?
Yeah. 240. My lord, my senior, Mr. Somen Datta is not available. I'm praying for not today.
What is the name of the petitioner?
My lord, it is Biraj Baran Khan.
Item 240. What is your name?
Kaushik Kormakar.
You are the advocate on record.
Yes, my lord. My counsel is, my lord.
So what, are you aware of the facts of the case?
My lord, let it be taken a day after.
Day after?
My lord, I'm praying for not today.
Only not today?
Today, my lord.
Who is your other side? State 240?
240, Mr. Devashi Shah is appearing on behalf of State Bank of India.
All right, then not today?
Not today, Lordship.
Mr. K.M. Hussain is appearing for the state.
Come on Monday? All right. Acta line order लिखे ने मैंने adjourned for the day on the prayer made on behalf of the learned advocate for the petitioner. Yes, 241. Dismissed.
I'm for the respondent bank.
My lord, this matter pertains to, my lord, a one-time settlement proposal. Petitioner made a proposal and thereafter, my lord, made upfront payment also.
SARFAESI
Action initiated.
proceeding
That
initiated.
is one thing, my lord. Because, my lord, your lordship knows, my lord, before.
Oh, 1 minute. Give me the dates. When was the NPA declared?
NPA declared, my lord.
What is the stage? 13-2, 13-4?
13-4 stage, my lord. No, there is
13-4?
yes.
Now, at this stage, is there any scope for one-time settlement?
So for one-time settlement, but they have acceded to my proposal. Only
Is the bank...
difficulty was, my lord.
If the bank admits, the court doesn't have a problem.
Lordship, they PTS proposal sanctioned on 21st March 2025. Time was 3 months, but they have failed to pay the same. However, as they thereafter requested some medical grounds, the bank is pleased to allow them another 15 days time from today if remaining amount. They have OTS amount was 15 lakhs. They have paid.
You come up with your proposal. I can record it in the order and dispose it.
They have
Give.
bank through mail. They have.
Yes, yes.
I have paid
Remaining
part payment.
with
The
the
petitioner
legal
seeks.
interest.
The petitioner seeks.
Interest, my lord, kindly wait.
One time. I am not waiving anything. It is for the bank to
It
waive.
is humanitarian ground, my lord.
I do not
Suffering
know.
from prolonged illness, my lord. That's why, my lord. Delay was not intentional.
The petitioner seeks one-time settlement. Stop. Learned advocate representing the bank submits upon instruction that the proposal of the petitioner for one-time settlement was accepted in March 2025 and time was allowed till June 2025 for making payment. Stop.
19th June.
The petitioner failed to act in terms of the proposal made. Stop. However, considering the medical condition
And part payment has been
highlighted
made.
by the borrower, comma, a further the further proposal for one-time settlement has been considered by the bank and the bank agrees to grant further time of 15 days.
Instead of 15 days, but can you make it?
1 minute. See, 15 days was from September. Now that 15-day period has expired.
So matter not called that time.
No, is the proposal still alive? I do not know
I
it.
ask them verbally.
Then
they
you
have
take
said-
further instruction so that it can be retained with the records.
Then keep it on next week.
Next week? All right.
Monday holiday due to Chhat thereafter.
No,
Who has given holiday?
Solid holiday for bank. Bank will be
Bank
closed.
has
That's
got a
why-
holiday.
yes.
All right. Acha, ki bollam?
But 1 month would suffice, my lord.
Agreed to grant further 15 days time for payment of the due amount. Stop. The time period allowed by the bank has expired during the annual vacation of this court. Stop. Paragraph. The petitioner prays time till, give me a date.
My lord, for at least 1 month, because festive season just, my lord, we have just passed the festive season, my lord. Kindly give me a breathing space.
30th November 2025 to pay off the entire dues. Stop. Learned advocate representing the bank is
My lordship penal.
Penal interest, my lord, let them consider, my lord, this is it.
আচ্ছা
Won't be
কি
too
বললাম 30th বললাম তো ওখানে আরেকটা লাইন অ্যাড আপ করুন যে the petitioner prays for waiving the penal interest. Stop. Learned advocate representing the bank is directed to revert with written instruction with regard to the proposal of the petitioner as mentioned herein above. ঠিক আছে? Released on 4th of November.
Lord,
Service is taken on record.
grateful to you.
Yes.
This is your lordship, my lord. Application under section 14 filed in the month of, my lord, on August 28, 2023, my lord, still pending. District Magistrate.
Your Lordship, Mr. Ramsar Mandal is appealing for the state. He is not well, Your Lordship, so kindly make it not to this board.
And you are not assisting him?
No, Your Lordship. In this matter, I am not assisting.
All right. Only not today?
Yes, Your Lordship.
On the prayer made by the learned advocate, made on behalf of the learned advocate representing the state respondents, hearing stands adjourned till 28th October.
Much obliged.
Yes,
Dismissed.
Let's go back to appear on behalf of the respondent bank.
Your Lordship, in this matter also, Mr. Mandal is appealing.
But then the answering respondents are here. Yes. Petitioner?
Yes, my lord, I appear on behalf of the petitioner. My lord, in respect of a cash credit facility, my lord, one-time settlement, my lord, was given. My lord, my husband, my lord, he paid. Thereafter, my lord, COVID period intervened, he died during COVID.
Lord, the petitioner, the wife, my lord, she offered to own up the liability and my lord asked my lord the balance amount to be paid. My lord, she went to the bank a number of times, my lord, nothing was intimated. Suddenly, page 39, this notice, my lord, is issued, which is 15th of February 2025. Well, kindly comes to page.
What happened to the sale?
Let's say the bank has already auctioned the property in favor of the auction purchaser.
And everything is over. Sale is complete.
Sale
Sale
is complete,
certificate
sale
issued.
certificate has been issued.
What remains? If you want to challenge the sale, you can go before the tribunal. Please come. The petitioner challenges the e-auction sale notice dated 15th February 2025 issued by the State Bank of India under SARFAESI Act. Stuff. Paragraph, learned advocate representing the bank submits upon instruction that the sale has been concluded and sale certificate issued in favor of the successful auction purchaser. Stuff. Next. In view of the aforesaid submission, nothing remains to be decided in the instant writ petition. Stop. The writ petition stands dismissed. Stop. Dismissal of the writ petition will, however, not stand in the way of the petitioner from approaching the competent forum for remedy in accordance with law, if so advised.
I'm deeply
Next.
obliged.
246 কি হলো? হয়ে গেছে? আগেই হয়ে গেছে। আচ্ছা।
The 247 of the petitioner. My lord, participated in auction the procedure, my lord. I was the highest bidder. I deposited the amount, the entire amount by 22nd of September 2023. My lord, the possession was not handed over on the plea of my lord pendency of the section 14 application. I found that my lord, the section 14 application was my lord submitted before the DM Paschim Bardhaman, whereas it would be the DM Purva Bardhaman. Thereafter, they made an application before the Purva Bardhaman, and that too, my lord, on 18th of September 2024. So, my lord, this is almost, my lord, 2 years, my lord, since, my lord, I have deposited the amount. But yet, my lord, the section 14 application has not been, my lord.
The bank has not come forward.
Lordship, and for the respondent number 3 and 4 bank, Lordship.
What is your submission?
Lordship, admittedly, Lordship, is pending, Lordship, section 14 we have filed in the.
What steps are you taking?
Lordship, that is pending, Lordship. May kindly direct the DM to Lordship the expedite the same, Lordship. They
They wrongfully submitted.
They have not made party, Lordship.
My lord, Purva Bardhaman has not been made a party.
Party, my lord, will be Purva Bardhaman. There is a mistake on my part, my lord. I will correct it.
Application has to be made.
My lord, that application has already been made before the Purva Bardhaman.
Nothing is annexed. Nothing is annexed.
My lord, kindly see page 21, my lord.
And admittedly, Lordship, they have purchased the property as is where is.
Achha, please come. Does it mean that you will not hand over possession?
Lordship, kindly see the bona fide.
Achha, the petitioner claims to be a successful auction purchaser of a property under SARFAESI Act. Stop. Grievance is that physical possession of the property has not been handed over till date. Stop. Prayer has been made to direct the bank to hand over physical possession of the auctioned property. Paragraph, learned advocate representing the bank submits upon instruction that proceeding under section 14 of the SARFAESI Act is pending before the competent authority. Stop. The bank admits payment of the auctioned amount by the auction purchaser. Stop. Paragraph. Upon hearing the submission made on behalf of the parties, it appears that the bank already received the payment on auction from the successful bidder. Stop. It will be the obligation and the responsibility of the bank to deliver possession of the auction property to the successful bidder. Stop. Paragraph. The instant writ petition accordingly stands disposed of by directing the bank to take all necessary steps to ensure that the possession of the auction property is handed over to the petitioner in accordance with law at the earliest without any further
Lordship,
delay.
may I, Lordship, may submit one thing. Lordship is aware that Lordship, how the district magistrates are now, Lordship, there is a lot of Section 14 applications are pending, Lordship. Lordship may kindly give a single line direction to the DM also, Lordship, so that they can, Lordship, take the initiative. We have filed it in due course and the hearing is, Lordship, in the process, Lordship. If they
Hearing is in the process.
yes, Lordship.
For how long?
Lordship, if they dispose of it's up to DM, Lordship. We
No,
cannot.
no, you say the hearing is under process. That means the DM has started hearing.
Lordship, if DM does not
Not
pass the
if. You have to make proper submission on facts. Has the DM taken cognizance of your application or is it just pending?
it's just pending. We have filed.
Then
and
the
it's not-
DM has not started hearing.
So, Lordship, may
You do not know the facts.
Lordship may kindly direct a single line only, Lordship, that to DM also. DM also represented, Lordship.
Right. The concerned, now the competent authority under section 14 shall keep in mind the time period mentioned under the SARFAESI Act to take steps under section 14 of the Act. That is enough.
Grateful, ma'am.
I beg to appear for the petitioner. This is my affidavit of service. So, my lord, before Lordship opening the brief, may I just candidly submit? It's a writ petition against a financial company, but the writ petition is maintainable. I'm not challenging any SARFAESI action, my lord. What has happened, my lord? In short, I'm telling you, Lordship.
Who is in other
We have-
side?
IIFL, my lord, I've already served. Why this writ petition maintainable? My lord, I'll come with that, my lord. Kindly, my lord, allow me a minute. May I just submit the fact, what has happened? Now, my lord, challenging a section 14 order, we have prepared this writ petition. This is our third round of litigations. Writ petition before the coordinate bench of your Lordship, my lord. We obtain a stay. Now, my lord, they are violating the stay, they have executed a section 14 order. We have filed a contempt application. Well, after, my lord, proceeding, my lord, hearing taken place on many occasions. Subsequently, the coordinate bench of your Lordship, my lord, a contempt jurisdiction directed the finance company to restore back the possession. Held them guilty of contempt. Now, my lord, after that, my lord, they have published a cell notice. We have filed a interlocutory application before the DRT. They have submitted before the DRT, no sale has taken place. Subsequently, what has happened, my lord? They have filed an appeal against that contempt order.
Who is appearing?
I have served.
The learned counsel. Who is the learned counsel? Who's appearing?
In appeal, my lord, I have annexed Mr. Gaurav. Ashok.
You ensure presence so that it can be heard because this is a contested matter and it cannot be taken up ex parte, right?
Yes.
None appears on behalf of the respondents. Stop affidavit of service filed in court is taken on record.
Like, I will again serve upon them, my lord.
Released on 4th of November.
4th of November.
Right. Let further intimation be served upon the respondents.
I'm grateful, my lord.
My lord, item number 241.
What has happened?
My lord, I am praying for not today.
Who are you appearing for?
Sheikh Anwar
Who is he representing?
for petitioner 241, item number 241.
Yes, 241. Dismiss for default হয়েছে 241 dismiss for default হয়েছিল ওটাকে recall করে দিন. Was the respondent appearing? এটাকে করে দিন, accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop released on released in the combined monthly list of November. Give your name. Two 49.
Your Lordship, back to appear on behalf of the Your Lordship petition.
Yes.
Praying for disposal of section 14 application.
Filed on.
Lordship, filed on in the 22nd of November 2024. Is appearing at page number 40. 40. At the bottom right hand side.
22nd November 2024.
Lordship.
DM Purbo Bardhaman.
Lordship.
All right, there's an usual order that will be passed.
Obliging.
Section 14 and a usual order.
My lord, the subsidy proceeding is pending before the date.
DRT. All right, let the DM take steps.
Opportunity given to us to.
Who are you?
I'm the private respondent.
Private respondent. All right. একটা line লিখে দিন. Learned advocate representing the private respondent submits upon instruction that a SARFAESI proceeding is pending before the Debts Recovery Tribunal being number Essay
50 of 2024.
50
50 of 2024.
name of the parties. Put it down in a piece of paper and hand it over. Disposed.
Obliging.
Service taken on record.
You pay for the state respondent, my lord.
250 stands dismissed.
Grateful to you.
Appearance to be recorded.
251.
Dismissed.
252.
Dismissed.
253.
Dismissed.
For the petitioner.
Yes.
Here, my lord, I am challenging the order or challenging the reply filed by the bank, my lord, with regard to the objection raised by the petitioner, my lord, with regard to the sale notice issued by the bank. My lord, the petitioner, my lord, lodged, my lord, grievance is this, my lord, the value while taking the valuation, my lord, that has to, firstly, my lord, no valuation report has been forwarded to the petitioner, my lord, in consonance with Rule 8.5. Secondly, my lord, the valuation has been done in a clandestine manner and without adhering to the due provision of law.
See, factual aspects the writ court cannot go into.
Because,
So
my
you
lord,
have
kindly
to
see my
uproot the-
objection, my lord, I am, my lord, against the cryptic reply. My lord, bank, my lord, when my lord, bank is dealing with the representation, my lord, at least, my lord, it is expected that they would give in, at least made an endeavor to, my lord, whatever, maybe reply may be bad, maybe, my lord, but it should not be non-speaking. My lord, I raised a concern that valuation report, I am the owner of the property, no valuation report has been forwarded, my property has been put up for sale. My lord, to
Where
that,
is the,
their answer is, well, kindly see their answer. They say that we have done
page
annexure P4, page 21.
Right.
Kindly see, they say that it has been done in consonance with the provision. When a specific issue has been raised, that no valuation report has been submitted to the borrower.
Say what specific data here, each and every.
Kindly see. And kindly see my representation, my lord. The preceding page, page 20, annexure P3. A specific allegation and assertion has been made that no valuation report has been forwarded to the borrower who is the owner of the property to take exception. But that is my legitimate right.
Show me your objection, please.
Well, kindly the preceding page, my lord, page 20, annexure
Page
P3.
20.
But you has got it.
Yes.
Well, kindly see.
What
The
have you
undersigned begs to
mentioned?
state that it has come to the knowledge, my lord, because since, my lord, it has not been forwarded to me, the
No,
undersigned
no.
notice
The
for
proper paragraph is 3.
Yes, yes.
That it is contrary to the statutory rules.
Yes, yes, my lord. At the outset, but I specifically assert that the impugned sale notice is grossly illegal and not sustainable in the higher law, inasmuch as the said sale notice has been issued in gross contravention of the statutory rules and regulation, and also in violation of Rule 8.5 of the SARFAESI rule by not forwarding the valuation report. Well, there is a specific assertion. But to that, they say we have done it in accordance with law. But they
Yes.
have never stated that we have forwarded the valuation report.
Show me that it is to be forwarded. Show me that
statute
is
says-
yes. So
My lord,
show.
kindly see, my lord, statute says a notice. Yes. My lord, I don't have a I am just taking your lordship to the Rule 851.
Yes, please show.
Kindly give me a minute, my lord.
Yes.
Come back ready on the
Before, yes,
next.
my lord, before effecting sale of the immovable property referred to sub-rule 1 of rule 9, the authorized officer shall obtain valuation of the property from an approved valuer, and in consultation with the secured creditor fix the reserve price of the property and may shall the whole or any part of such immovable property secured by any of the following methods.
Yes.
The,
So
the
you
methods
go.
have been entered thereafter. The authorized officer shall also refer to the borrower a notice 30 days for sale of the immovable secured asset under sub-rule 5. So
Yes.
therefore, what first it envisages.
So the
that
sale notice has already been published.
Sale notice has been published, but with the
Huh.
sale notice, but the valuation report has not been forwarded. So, but I have got no knowledge about the valuation. But and the manner in which the valuation has been done. It's my property, my lord. At least,
Yes.
my lord, as per the national.
What happened? What happened to the sale notice?
My lord, the sale notice, my lord,
It was in February.
I have to. It has become infructuous. Yes, my lord, the sale notice. Sale is about to take place on 28 June 2025. That was the, my lord, my lord, I have to take in, and the notice is at page annexure P2, page 18, my lord. Your lordship will find e-auction sale notice.
None appears on behalf of the respondents. Stop, let further notice be issued. Stop, released on 4th of November.
Lordship. Grateful, my lord.
I'm for the state, my lord.
Similar, my prayer is, I am for the bank. Prayer, my lord, is for me to implement the action upon the, my lord, state authority, police authorities to implement the order of the district magistrate.
Show me.
My lord, kindly see the order.
EM's order.
After 15 February 2024, page, my lord, page 34. District magistrate passed the order. I have requested my lord, SP, my lord, and my lord, to my lord, to deposit my police cost, but no steps there. Order is, my lord, page 34.
You are the bank.
My lord. Yes, we directed, my lord.
Yes, the
Allow us to deposit police cost. My lord, there are
this
police
remain present.
to implement the
We
order.
will take in advance. We take physical possession. Application for police assistance made 2024. Okay. Then thereafter nothing happened.
Nothing happened. My lord, this is evidence.
State. Yes.
Lord, although I do not have the instructions, my lord, I should not stand in the way of the
Right.
petitioner prayer.
Please come. The petitioner
But
prays
that's
for
6 to 8.
execution.
I will private respondent 6 to 8.
What is your submission?
But I have no submission, my lord.
You filed your wakalatnama?
Yes.
5 to 16, please check. Praise for execution of the order dated 15th February 2024, passed by the District Magistrate, South 24 Parganas, under Section 14 of the SARFAESI Act. (14) 1A of the SARFAESI Act. Stop. The petitioner bank deposited the cost for police assistance way back in May 2024, but till date, no steps have been taken for handing over physical possession of the auction property to the successful bidder. Stuff paragraph. As the district magistrate passed order under the provisions of the SARFAESI Act for handing over physical possession of the property, the said authority ought to ensure that the order is implemented. Stuff. The time period within which the order ought to have been the instant writ petition is disposed of by directing the district magistrate South 24 Parganas to ensure execution of the order dated 15th February 2024 at the earliest without any further delay. Stop. Without any further delay, as enough time has elapsed after the petitioner deposited the cost for providing police assistance for taking over physical possession of the secured asset. Stuff. Next, the DM shall ensure that the order is implemented latest within a period of 4 months from the date of communication of this order disposed. Next one is also same. Same. Next one.
Same.
Date.
That is also same. Order DM's order same date.
DM's order is same. The DM is also same, and everything is same. Same order.
Respondents are another.
Maybe, but then the order is the same. আগেরটাতে বকালতনামা দেয়নি? চলে গেল?
Video service kept the record.
আগেরটাতে প্রাইভেট রেসপন্ডেন্টের নাম দিয়েছে? ওখানে লিখে দেবেন ওকালতনামা নট ফাইল্ড। প্রাইভেট রেসপন্ডেন্ট ওকালতনামা নট ফাইল্ড।
72. But I want the respondent, private respondent. Well, here, my lord, an application. Thank you.
I am appearing on behalf of the petition, my lord. The application under section 14, my lord, has been filed in the month of February 28, 2023. I'm just wanting enforcement, disposal of that application, my lord.
But only one thing, my lord, this application has been made way back in the year 2023. That is still pending. Now, your lordship knows, my lord, there is a statutory, my lord, there is a mandate that.
1 minute, 1 minute. Where is the order? Please show me.
My lord, order has not been passed, my lord. Only application pending, my lord.
Where is the application?
My lord, the communication is there at page 19 to the district magistrate Havla that my application has been pending, my lord. It's serial number 2.
Where is this serial number 2?
At page 19, my lord.
Page 19. Serial number 2, where is it mentioned?
My lord, memo number such and such dated February 28 to 2023, my lord.
Borrower, there are 4 borrowers. Is it this one proceeding or separate proceedings?
My lord, separate applications are pending, my lord, which is concerned this writ petition, my lord. That is at item number 2.
Mrs. Gram Bangla?
My lord.
All right, here in Kolkata, 28th of February 2023. Hearing completed, order not received. 9th of January 2025. Who's for the state? Service made?
My lord, service is complete. My lord, affidavit of service.
My lord, DM is required to give a explanation, my lord, why this inordinate delay. My lord, your lordship knows there is the mandate of the statute is very clear.
How is the this submission?
I have a right under the act, that's why. I cannot point out.
The petitioner,
and SARFAESI is pending also.
Being the secured creditor, has approached this court seeking a direction upon the district magistrate, Howrah, to conclude the proceeding initiated under section 14 of the SARFAESI Act. Stop. From a communication made by the bank to the district magistrate dated 9th January 2025, it appears that Hearing of the Section 14 application stood completed, but final order was not passed. Stop paragraph. The Section 14 authority ought to take steps strictly in terms of Section 14 of the strictly in terms of the Act, wherein time limit has been prescribed for conclusion of the said proceeding. Stop. The time limit for concluding the proceeding appears to have expired long back. Stop. The instant writ petition stands disposed of by directing the district magistrate and district magistrate Howrah to take steps for concluding the Section 14 application without any further delay. Disposed.
And my lord, SARFAESI application is pending. Your lordship,
The application in accordance with law. Ekhane.
Within a certain time limit can be.
See, the Act has prescribed a
16 days,
time
my lord.
limit.
2 years is
Why will the court extend or reduce the time? Whatever is there. Private respondent at a boktobo likhenin. Learned advocate
SARFAESI
representing the private respondent has wakalatnama been filed.
My lord, yes, Wakalto file kora hai. Yes, my lord, Wakalto has filed.
Please check. Submits upon instruction that the securitization application at the instance of the private respondent is pending
Yes, sir,
consideration before the
45.
give the number
Yes, yes.
and the name of the parties also
Yes, yes, ma'am.
is pending consideration before the debts recovery
Very time,
tribunal.
Much obliged.
Dismissed. Dismiss.
Millet for the respondent bank bill.
Dismissed.
Much obliged.
Lordship, Miss Shabuni Sarkar is appearing for the petition. I'm praying for not today.
Lordship, accommodation sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 3rd
Lordship.
November.
They reach.
For the bank in this
263
matter.
হয়ে গেছিল আগে
264 manner for the bank in this matter.
Is the petitioner there? Dismissed. Give your appearance, please. Dismissed for default. Dismissed.
The petition led by Ritik Chaudhary.
My lord, 266, my lord, 266, I am appearing for the petitioner. My lord.
Yes, please.
And this is our affidavit in service.
The service is complete. The primary respondent in this matter is the State Bank of India, my lord.
Yes.
My lord, if I may place the facts.
Yes,
My lord, the respondent has published an advertisement for selling a 2,900 square feet flat along with 2 car parking space in Silver Spring apartment, but through an auction. My lord, the petitioner participated in the auction, was declared the highest bidder, paid the entire sum by taking a loan from the same respondent bank. And since then, the petitioner is paying the monthly installment without any fail. Well, despite making payment of the entire sum, the possession of the property has not been handed over by the respondent bank. My lord, when the respondent bank along with the petitioner approached to take possession, the apartment owners association has restrained them on the account that there is some maintenance due and some other dues from the previous owner, and that's why they won't allow us. Lord, I am paying monthly installments since the month of February 2025 every month. The flat is of 2.6 crore and I'm paying a monthly installment of 1.5 lakhs every month without fail. despite which I am not in possession of the property, my lord. If I may place the papers, my lord, once.
No, you have placed your case very succinctly and I have followed what the grievance is. Please come. The petitioner is aggrieved by the action on the part of the respondent number 5 in not permitting the petitioner to take physical possession of the property purchased by the petitioner on auction under the provisions of the SARFAESI Act, allegedly on the ground that there are maintenance dues pending of the previous owner. Stop. Upon hearing the submission of the petitioner, it appears that the dispute in question is an absolute private dispute in between the parties. Stop. There is no public element involved in the instant writ petition. Stop. In the event the petitioner has any grievance against the Apartment Owners Association, it will be open for the petitioner to take appropriate remedy before the competent forum in accordance with
My lord,
law.
if I may, my lord, the respondent, the primary bank is a PSU bank, my lord. My lord, the State Bank of India is supposed to hand over the possession. The State Bank has taken money from me.
Oblige, Your Lordship.
My lord, if
My lord, I am appearing for respondent number 3, 4, and 5 in this matter, madam.
264.
67.
267, you are for the
Respondent 3, 4, and 5, Canara Bank. In this order, my lord has passed an earlier order to consider the proposal of this. We had duly replied to the order. I am giving 2 letters.
Yes.
One letter is already annexed at page number 75 of the writ petition, wherein, my lord may see the prayer of the petitioner is praying for writing of a housing loan of 56 lakhs, which is not permissible for a public sector bank. We had duly replied in the manner. My lord may see the letter handed at page number 75, which was issued by the bank in view of the earlier order passed in the writ petition. Thereafter, again, one letter.
This is page 75 is under challenge.
After page 75, yes.
Is under challenge.
My lord may come to the prayer portion.
Very well. Is the petitioner represented?
My lord, petitioner is not there.
Very well. Dismiss for default.
Prayer A is the.
Dismiss for default.
My lord, 264, my lord, I am appearing for the state, my lord, shall I give my name, my lord?
No, but then you were not there at the time of hearing.
Just come for running.
Then,
to the court number.
if you were not there,
Lord, kindly allow.
then
I appear for respond number 1 and 2, my lord, in this matter.
dismiss for default.
No.
8.
Dr. Penaitan,
Lord, 269, my lord, I appear for the petition.
Madam, for the state, my lord.
269.
My lord, I appear for the petition, my lord.
Yes.
My lord, my video has been kept off, my lord, by the.
What is the matter about?
Lord, Lord, this is a matter pertaining to an issue, my lord, kindly comes first to the, my lord, the order passed by the DM, my lord, that is on 8th of January 2015 in respect of several loan facilities granted to the private respondent number 4. Now, there are several loan facilities. Now, my lord, apropos that, my lord, DM passed the order on 8th of January 2015. Now, thereafter, my lord, it was detected.
Page.
My lord, 8th of January is at page 30. That's the order of the DM.
Yes.
Now, my lord, your lordship will find on 6th of February 2015, an FIR in form of a written complaint is lodged by the Bravan Road branch. Lord, I am not the Bravan Road branch. The another branch of the Bank of Baroda lodges a written complaint against one of the directors of the private respondent number 4. That's New Look. That your lordship will find at page 36 on account of forgery made by the private respondent. Now, apropos that, on 3rd of March 2015, the investigating agency issues a notice under section 91 of CRPC for production of documents. Now, the particulars of which we have mentioned in paragraph 7. Now, my lord, kindly sees page 38, that's annexure P5. My lord, these are the seized documents by the investigating agency. That seized on 25th of March 2015. My lord, till date, my lord, there are several documents, my lord, which are the original title deeds, which have been mortgaged by the borrower. That is the private respondent number 4. My lord, they are still lying with the investigating agencies. Now, my lord, we have made 2 representations. My lord, kindly comes to the first representation dated 26th of April 2024, that your lordship will find at page 42. Lord, here, my lord, we clearly state that till date, my lord, we are unaware about the progress of the investigation, or if any trial has commenced, or if any steps have been taken. Now, my lord, the difficulty which we are facing, my lord, there are several properties which belong to this borrower. Several credit facilities have been granted. Now, my lord, in pursuance of that, my lord, SARFAESI proceedings, my lord, sales certificates have been issued, which your lordship will find from page 47 onwards. Your lordship will kindly take note of the fact at page 47. The name of the borrower, that is Newlock Intex in Nirman Private Limited, is there in respect of all the 4 sales certificates which have been issued by the bank. Now, the difficulty is, in spite of receiving the money, we cannot hand over possession because the original auction purchaser are not willing to take this, because we cannot provide them with the original deeds which are lying with the investigating agency. Now, 10 years have elapsed. What is preventing them from handing over the original title deeds, the particulars of which have been mentioned in paragraph 7? This is the issue before your lordship.
So you are aggrieved by the action of the police.
To an extent, because it is before them now.
Now, why before this bench then? Why don't you go before the police in action bench?
That perhaps, since it's pertaining to a SARFAESI proceedings, because
maybe the proceeding is SARFAESI, but then you do not want
lordship,
any relief under the
if your
SARFAESI.
lordship directs, then we shall go before the appropriate bench. Because as it failed,
1 minute. The state has some instruction.
Instruction, my lord.
Yes.
So the trial is pending.
Yes.
Documents has been seized. My last paragraph of the first page, my lord. It is under DDMK number 157 of 18, dated 29th March 2018, my lord. My lord, since the trial is pending, my lord, subject to correction, my lord, my learned friend should have approached the trial court for this release of this.
We are not aware of anything. This is the document which is coming for the first time. My lord, if your lordship records this document, if he hands over a copy, my lord, we shall take appropriate steps under section 451 of CRPC. My lord, there is a provision under the law, my lord.
DDMK number.
Yes, my lord. The DD Malkhana.
Because, my lord, the investigating agency has not informed us anything till date.
Submissions, my lord.
Trial, what is the case is currently under trial. So under trial means a lot of things. Trial is not a one-day affair. It takes time.
Yes, ma'am.
Charge sheet number is given.
Only if the trial
The
court,
court number is given.
only if the trial court, my lord, gives order that it is, we can give them the.
No, that I understand. Please come. The petitioner, bank, despite putting up the secured asset for sale, SALE, is unable to hand over physical possession of the same for want of original title deed of the property, which which were seized by the police. In response to an FIR registered in respect of the subject property stuff. Prayer has been made to direct the police to take the petitioner is unaware of the fate of the criminal proceeding. Request was made before the police for taking steps for returning the original documents. But
But only one indication, Milord, kindly comes to paragraph number 9.
yes,
Milord, there are certain documents which have got nothing to do with the investigation, Milord, which I have specifically stated.
see, all these things the writ court over here cannot look into. FIR একটা বললাম, date, the date, page 38, the date is there, the case number is there, and the sections are there. ঠিক আছে? আচ্ছা, last কি বললাম? To return the original title deeds to the bank. Stop. Paragraph. Learned advocate representing the state respondents has obtained instruction from the concerned police station, wherefrom it appears that the investigation in connection with the FIR is over and charge sheet being CS number 81/18 was submitted before the learned 20th Judicial Magistrate Calcutta on 23rd June 2018. Stop. The subject case is currently under trial. Stop. The documents seized during investigation, including the property deeds on 25th March 2015, was recorded and kept under DDMK number 157/18 dated 29th March 2018. Stop. The documents are required to be produced before the learned trial court as and when required. Stop. As the criminal case is under progress, the police is unable to return the documents sought for by the petitioner. Stop. Paragraph. Upon hearing the submission made on behalf of the parties, the instant writ petition stands disposed of by observing that it will be open for the petitioner to take steps before the competent forum seeking return of the documents seized by the police in respect of a criminal proceeding that is pending before the criminal court. Disposed.
Grateful.
Grateful, dear Lord. The 271, my lord, I appear for the petitioner.
Yes.
Lord, this is for implementation of an order passed by the learned district magistrate. Lord, kindly state.
Dated.
My lord, it's dated, kindly comes to page 60. My lord, it's dated 21st of January 2022. Lord, what has happened here, my lord? The order was passed. My lord, now, my lord, the executive magistrate has to implement it. My lord, the executive magistrate did not implement. My lord, intimation was served by the office of the DM on 16th of July 2024 that the same would be implemented. Lord, subsequent to that, my lord, the borrower persuaded with the SARFAESI proceedings. Now, your lordship will find at page 66, that is the final order passed by the learned debt recovery tribunal by dismissing the SARFAESI application filed by the borrower. So, my lord, today there was no impediment in implementing the order. Now, my lord, what the borrower does, my lord, he sets up a tenant. My lord, the usual defense, my lord, that is covered by your lordship's judgment. My lord, kindly see that page 70, my lord, he sets up a tenant and obtains an ad interim order of injunction.
Yes.
So, my lord, no, my lord, this is not a tenant. My lord, he obtains, my lord, an order. He files a partition suit. I'm sorry, my lord, he files a partition suit. Kindly comes to page 70.
How can a tenant file a partition suit?
No, my lord, I'm sorry, it's not a tenant. I'm sorry, my lord. This is another matter, that's the tenant. It's 274. I got, my lord. My lord, kindly comes to page 70. My lord, he files a suit for partition, declaration, and injunction amongst, my lord, the alleged co-sharers. But, my lord, bank is not a party to it. My lord, bank has got nothing to do with it. And, my lord, this has been only filed after the SARFAESI application has been dismissed. and the order passed by the DM is in 2022. Now, my lord, I am covered by your lordship's judgment. My lord, if my junior may hand over to your lordship, in similar circumstances, your lordship had the occasion to deal with it.
Let me see.
That's your lordship's order dated 11th of September 2025.
Yes.
Well, it is more or less a similar circumstances your lordship find. This is with regard to the tenant, defense being set up by a tenant.
No, but then this is different, isn't it?
Different in the context, my lord, your lordship will find, my lord, it's only the nomenclature, my lord. Your lordship will if a partition, my lord, kindly appreciates, if a partition suit has to be filed, it could have been filed at any point of time.
That
Bank
is
has
for
a
the
right, my lord, bank has a right to enforce the secured asset. Now, my lord, the SARFAESI application got dismissed. The section 14 order, my lord, has been affirmed. So, my lord, nothing remains today which will prevent, my lord, the executive magistrate or the DM from implementing the order. The order passed by the civil court is only in respect of the co-sharers at best and not binding upon the bank. So
yes.
that is what your lordship, the ratio of your lordship's judgment is all about.
Please come. The petitioner bank. No, not bank. It's a non-banking financial.
Non-banking financial.
Financial company seeks execution of the order dated 23rd February 2022 passed by the district magistrate, South 24 Parganas. Stuff. The district magistrate Videk, communication dated 16th of July 2024 intimated the petitioner about the representative of the district magistrate for taking physical possession of the property under the SARFAESI Act. Stop. The said order is yet to be implemented. Stop. It appears that the subject property, that the securitization application filed by the borrower before the Debts Recovery Tribunal stood dismissed. Before the Debts Recovery Tribunal being SA number 314/2021 stood dismissed on 21st of March 2024. Stop. Paragraph. According to the petitioner, there is no impediment on the part of the district magistrate from executing the order passed by the DM under the SARFAESI Act. Stop. Paragraph. It has been submitted that the subject property has thereafter been made a part of the title suit being number 572 of 2025.
Now, this is 1 year after the order passed by the DRT.
Where from does it appear that it is a partition suit?
No, lordship kindly takes up page 70, my lord.
70, I am at 70.
Yes, peruse the plain. This is a suit for partition, declaration, and injunction. Lord, the third, fourth paragraph, my lord. Peruse the plaint, application for injunction, and the documents produced by the plaintiffs, supported by affidavit and verification. Thereafter, my lord, this is a suit for partition.
1 minute. This is a suit for partition. কি বললাম? For partition, declaration and injunction.
And only order in respect of maintaining status quo has been mentioned. There's nothing else. Well, kindly comes to the ordering portion.
Yes. Now, what does status quo mean? Does the bank go and...
Bank has an independent right. Otherwise, what would happen? Everybody would set up a defense.
The bank is not a party in the... the petitioner.
Petitioner
is not a party in the partition suit. Stuff. the did the DM intimate you that they are not taking steps because of the order passed by the
Well,
trial court?
we had made two representations. Well, your lordship will find at
Page-
page 73 and page 76.
Not considered, not
Not disposed of. Thereafter, my lord, we inquired, we found out that one suit, an
Very
injunction order has been passed. But that is not binding upon us, my lord.
the as it appears now, as no order from any competent court of law has been produced before this court, staying the operation of the proceedings under the SARFAESI Act, accordingly, the authority under section 14 ought to take steps for implementing the order passed under the under the aforesaid section. Stop. Paragraph. The instant writ petition accordingly stands disposed of by directing the District Magistrate, South 24 Parganas, to take prompt necessary steps for implementation of the order dated 23rd February 2022 at the earliest, but positively within a period of 6 months from the date of communication of this order. Disposed.
Grateful to your lordship.
এটা ফেরত দিয়ে দিন, লাগছে না। আর নয়, বলো।
Item number 267, your lordship, I am not appear before your lordship, dismissed for default, 267.
Yes.
Restore it, take up the matter, your lordship. Monthly list 267, just.
Was your other side present?
I do not know, I come up to 59, 69 at the time of 269.
267. Other side was there. What is the name? You let him bring your other side.
Yes, ma'am.
2 o'clock. Yes.
Under list 267.
I am for the petitioner, my lord.
Yes.
Lord, this is my affidavit of service. I have served. Lord, this is the second time petitioner filed the petition. Petitioner is the helpless widow, my lord. Her husband, my lord, taking loan from the Canada Bank, 56 lakhs in the year 2022. 22.
No, but then your proposal for one-time settlement or something has been
Yes, yes,
rejected.
that was not considered, madam. Kindly see.
It has been rejected.
Rejected. Madam, there is no any reason. I mean, without any opportunity of hearing, they rejected my claim.
No, no, all the time you cannot have opportunity, and moreover, your SARFAESI application is pending.
I have every month, I pay the.
Your SARFAESI application is pending consideration.
No. They have no. I am not a defaulter, my lord. Every month, I paid 48,000 installment. I obtained my pension, 35,000.
Whatever.
I am not able to run my family, my lord. I have a son and mother-in-law, my lord. I am not able to run my family, my lord. 35,000 my pension, my lord. I paid
52 lakh.
48,000 installment, my lord.
My lord, this is the loan sanction letter in year 2020. Pijut Kanti Ghosh, husband, and Suchandra Mandal petitioner availed a house and renovation loan for an amount of rupees 56 lakhs.
Yes.
My lord, they want to write off of the entire.
Oh, they want to
write
write it off.
Entire, my lord. I have already paid, my lord, already up to 2025 till today, my lord. I am not a defaulter, my lord. Every month I have paid. Every month I have paid. But I am not able.
How have you considered it?
My lord, where is the question of my lord? What is their prayer? My lord, they want that this government scheme, that government scheme.
No, no, whatever. The write-off you considered, you mentioned that you considered it and rejected it.
75, my lord. Page 75.
Page 75.
Yes.
There is no any reason, my lord.
17th of
First of all,
July.
when there is a security in the account,
yes,
of cannot be considered when there is a security value attached. As per the banking norms, when we don't have a security, my lord knows very well, where it's a clean loan, it's an unsecured loan, then the question.
Why don't you intimate the petitioner?
It is intimated, my lord. These letters have been intimated.
Where is it?
It is. He has received this letter, page number 75. He has received. And later on, again, we have issued a letter on 19th of August, which we have sent it through post.
No, overdue and total outstanding as on date is 52.
My lord, may see the letter below. It is been received by Suchandra Mandal Ghosh, signature. I have already tendered it.
Yes. Right.
As per banking norms, my lord,
why don't you intimate the petitioner that why you are not being able to accept the prayer for write-off?
Write-off is the last. Write-off cannot be done. My lord very well knows banking norms. When there is a security, the house is itself is.
Let the petitioner know that. You have not done anything. You have only mentioned you keep the account regular.
No, this is the latest one where they have again paid the amount and the account is now regular.
You admit that the account is regular.
No necessary steps. You are requested to keep the account regular. Otherwise, we will take necessary steps against.
Yes.
The account is regular, so we won't be taking.
No. There is no question of taking steps when the account is regular.
Yes.
Thing is that the petitioner, who is the loanee, is not in a position to pay off the loan. He is a retired employee or something.
My lord,
widow of the
retired employee.
Obtained 35,000.
Who obtained the loan?
Yes, my
It's
husband.
a joint loan. I have given the it's a joint loan.
Joint loan,
It's a letter of.
The husband was
assistant teacher of the high school.
He has expired.
Yes, due to accident, road accident, my lord.
Now, in the change circumstances, please check up what can be done. The lady is not in a position to pay off the loan. And then you'll start proceeding under the SARFAESI and you'll take the secured asset that is over there. This is what you will do.
That is what will be done, my lord.
There must be something you please check up.
My lord, there is no such provision because when there is a security,
please come.
Even they are not giving any OTS proposal कि we want to settle in such an amount. There is no such proposal also. It to the sanction.
No, you file a report. The petitioner is the widow. of a deceased school teacher, or what you said? Deceased high school teacher
Yes, ma'am.
who succumbed, SUCCUMBED, to a road accident on 14th of May 2024, leaving behind one minor son, his ailing mother, and the petitioner as heirs and legal representatives. Stop. Paragraph. While in service, the husband of the petitioner, along with the petitioner, availed a house building loan after the death of her husband, the petitioner is not in a position to pay off the loan amount. Stop. The petitioner prays for a direction upon the bank to write off the loan and to return the documents of the property on mortgage. Stop. Paragraph. The bank is not agreeable to the same. Stop. It has been submitted that there is no provision to write off a loan when there is a property mortgaged in connection with the loan account. Stop. Paragraph. The bank is directed to file a report disclosing its stand. Stop. The condition of the petitioner on the untimely death of her husband. The condition of the petitioner on the untimely death of her husband will also be taken into consideration at the time of preparation of the report. Stop.
My lord, my humble submission is they are asking for write-off of the principal and the along with entire interest.
Yes, the entire loan amount they are trying to write it off.
Write-off.
Right?
Which
That
is-
means closure of the loan.
Without offering any amount.
I can understand.
And we are a nationalized bank which will
The affidavit shall be made ready and circulated by, how soon can you do it? 2 weeks?
3 weeks, because 1 week will be again leave and all.
19th of November. List in the monthly list of December. It will be open for the petitioner to file a reply to the report prior to the urgent date of hearing.
Deep.
Right.
On to the petitioner, my lord.
I'm appearing on
Section
Yes.
15 application, my lord. The DM application is pending since 7/1/2025. 13/2, 13/4, all those things have been done.
You are for?
State.
No. In item number 272, I have for college authority. What is the cost?
This is the combined list matter. There is no college over here.
Subinita Banerjee.
There is no such party. Yes, show me your application.
My lord, the DM application is pending since 7/1/2025.
Where is your application?
That's at annexure P3, page 19. 19 onwards. Both the application and the affidavit.
Date is, where do I get the date? 7th January 25?
Yes, my lord.
All right. Section 14. There's an usual order that will be passed.
Grateful, your lordship.
Review section 14 usual order. Section 14 এর একটা usual order আছে SARFAESI page 19 দরখাস্ত আছে, date আছে DM.
I'm from the petitioner.
Yes.
Lord, I have appearing on behalf of the tenant. Lord, here the fact relates to, my lord, that a purported impugned sale notice has been issued by the bank. Although, my lord, there is an already status quo order, a decree has been passed in favor of the, my lord, tenant by the civil court. Not only that, my lord, my earlier SARFAESI application has been disposed of. Well, I straightaway I will take your lordship to page 34. My lord, the observation made by the learned presiding officer. Your lordship, kindly come to page 37. Well, my lord, paragraph 5, my lord, that on perusal of the instant application and the documents annexed to it is observed that the applicant is a tenant under the respondent number 326. That is the bank. Apart from other white tenancy agreement dated 1st January 2000, in respect of the subproof number such and such, the ground floor of 3-storied building, Kalpataru complex, and also annex certain rent received in the name of applicant further. Further, in view of the order dated 12 May 2017, the order passed by the civil court, granting a ex parte degree in favor of the tenant, passed by the learned civil judge junior division 2nd court, Bardwan, in case number such and such, in view of the provision under section 17(4), it is held that the applicant is a lawful and bona fide tenant. The apex court has laid down the provision in case of Harshad Govardhan Sonkar and such and such. This tribunal finds that the despite this question is civil in nature, that the civil courts are only vested with the power to malad. Well, pausing here for a moment, malad, there is a categorical malad observation.
What is your prayer over here?
Malad, my prayer is malad, after this order passed by the malad, the bank malad has been malad all restrained from taking any further steps under the SARFAESI Act.
What is the impugned order?
Malad, the
what is the interim order that was granted?
But the interim order, malad, the decree has been passed in favor. That decree, malad, I will show to your lordship.
21st
Kindly
March.
come to, malad, annexure P2.
1 minute.
Annexure
21st March 2018. Show me that order, please.
Yes, malad. That the instant suit is, malad, page 31, annexure P2. That the instant suit, the under same is decreed, ex parte against the defendant.
Oh, show me 21st March 2018 order which stood vacated.
Well, that is the interim order passed by the tribunal. But that order, my lord, is respectful submission, my lord, is not annexed here, my lord.
Oh,
because it is the final order. Now, interim order, my lord, initial protection has granted to the petitioner, but since, my lord, this is the final hearing, the outcome of the final hearing, and ultimately, my lord, the SARFAESI has been disposed of, my lord, directing the bank to approach the civil court for redressal of its grievance.
Yes, so you are aggrieved by this order?
No, I am not aggrieved by this order, but I am the tenant. But what has happened subsequently, but I am aggrieved by the impugned sale notice. But that sale notice, now I cannot approach the tribunal, but since the tribunal itself observed that the civil court is the, my lord, the appropriate forum. Now, what has happened, my lord, in the meantime, my lord, they have issued a purported impugned e-auction sale notice dated 5 July 2025. 2025.
What
So
happened? What happened?
My lord, that sale is supposed to take place in the month of August. My lord, since I am the tenant, my lord, nothing has been intimated to me because I am not the landowner, my lord, or not the, my lord, the borrower. So I do not know the outcome of the sale. But since
You are
there
still in
is already,
possession.
my lord, embargo,
No, if you are still in possession, remain in possession.
I'm in possession, but kindly observe that so far the sale, if any, that will have got no bearing so far I am concerned.
No, no.
I am saying quashing of the entire process, matter could not be taken up because it's appearing in the list. But kindly see, since the already the landed presiding officer, they have not preferred any appeal against that. I can understand, if they are aggrieved by the said order, they could have preferred an appeal. They could have went higher up, but they have not done that. They have accepted the order. Now, it does not damage.
Please come. None represents the respondents. Stop let further notice be served. Stop released on 3rd November 2025.
3rd November,
Combined list it will be
Very
there.
well, I will inform them.
Service is taken on record.
Grateful to you.
274, my lord, I appear for the petitioner. My lord, this is also implementation of the district magistrate order. My lord, the same issue, my lord, defense of tenant has been set up. My lord, your lordship will find the order passed by the district magistrate at page 27, 5th of March 2025.
Yes.
Thereafter, your lordship will find, my lord, after the order has been passed on 7th of May 2025, my lord, a fake tenant dispute has been, my lord, arisen. My lord, usual orders, my lord, these are the ways, my lord, your lordship knows to stall the orders passed by the magistrate under section 14, where bank is not a party. That's at page 30. My lord, we communicate to the executive magistrate who is going to implement the order. That is at page 31, 27th of June 2025. My lord, the order is yet to be implemented. My lord, I am protected by your lordship's judgment, my lord, which I have handed over. That was... Pardon, your lordship?
The petitioner, financial institution seeks implementation of the direction passed by the District Magistrate South 24 Parganas on 5th March 2025 under the SARFAESI Act. Stop. As the order was passed by the District Magistrate, the said authority ought to take steps for implementing the said order. Stop. Next. The instant writ petition stands disposed of by directing the District Magistrate South 24 Parganas to take immediate steps for implementing the order dated 5th March 2025 in accordance with law at the earliest.
My lord, will also add, my lord, this order passed by the civil court will have no bearing on him, because this is the difficulty that is coming up.
At the earliest, provided there is no order from any competent forum restraining the authority from implementing the same. Disposed. Service is taken on record.
Grateful to your lordship.
25. Lordship, in item number 275, I am appearing on behalf of the petitioner, your lordship. I humbly pray for not today, your lordship. Kindly it be fixed on 3rd, 4th, any day, your lordship.
3rd and 4th?
3rd, lordship.
Kindly
3rd
see
November.
the conduct of the, my lord, the authorities.
Yes.
My lord, order was passed under section 14. Possession have been taken by the writ petitioner herein. At page 60, at page, my lord, 63.
Then?
Now coming and saying that section 14 order be implemented.
Possession taken?
Taken. Kindly
Lordship,
come to page
lordship,
63.
there needs to be a long hearing, lordship. I'm
Page
being led by
63.
Mr. Abhishek Guha. Lordship, kindly keeps it on 3rd.
Seal, authorized officer.
It's
ARCIL.
28th of November 2024. Possession of the product handed over on such and such to such and such asset. Yes.
Taken possession and then coming and asking for implementation of the order of under section 14.
Lordship,
My lord, I'm sorry to intervene. My lord, may I assist your lordship? My lord, the brief has not yet been sent to me. My lord, the question here is, my lord, there's a judgment of this honorable court. Justice Bhattacharya's judgment is there. My lord, even if one's possession has been handed over, the possession has to be absolute. If some third party steps into it and, my lord, takes possession, it is the duty of the DM to put the financial creditor or my lord, the bank back into possession. My lord, I shall rely on that judgment.
No, sorry, I couldn't get it. You make an application under
lord,
section
yes,
14
my lord,
that is considered allowed and executed.
Executed to an extent, but thereafter, my lord, if there is an impediment created by any third party, but the law says, my lord, I'll rely on that judgment. Today, my lord, I'm not equipped with it. Now, that is why, my lord, my junior has, my lord, prayed for time. My lord, I'll show to your lordship the judgment of Justice Bhattacharya, which has apropos dealt with this situation, where, my lord, possession, even if has been handed over and kindly takes it upon 3rd of November, I shall apprise your lordship, my lord.
The petitioner, financial institution seeks implementation of the order passed by the district magistrate under section 14 of the SARFAESI Act. From the documents annexed to the writ petition, it appears that possession of the property was already taken by representatives of the petitioner way back on 28th November 2024. The instant writ petition has been filed in August 2025, seeking implementation of the same order passed by the district magistrate. Learned advocate for the petitioner intends to make submission with regard to the maintainability of the writ petition. Released on 4th of November 2025.
Grateful to your lordship.
Good. Item number 276, Miss Onkita De is appearing on behalf of the petitioner. There's a medical emergency at her house. She has not come to court. I'm praying for days accommodation.
You are there.
Appearing for the bank, my lord, only one request I had. They have not served yet.
Please serve a copy. The matter stands adjourned till 3rd November 2025 on the prayer made on behalf of the learned advocate representing the petitioners.
I'm for the petition.
Yes.
I'm taking a preliminary point regarding the maintainability. I'm appealing for
Who are you?
I'm appealing for the Chief Judicial Magistrate Alipur.
All right.
I passed the order, my lord, under section 14 rejecting the application. There is an appellate provision.
Yes, please.
From section 14 order, I cannot appeal.
Why not?
I cannot challenge that order.
Order of the judicial magistrate.
It's a ministerial order.
Yes.
In terms of section 14(3), my lord, I cannot
Yes.
challenge that order. So, my lord, I am remedialess. Kindly
What is the ground of rejection?
My lord, kindly comes to page 104.
Yes.
My application was rejected on the ground that the description of the property was not particularly mentioned in the sanction letter and in the agreement. So, my application is not complete. That was the ground for rejection of that my application. Kindly comes to 104.
Yes.
May I be allowed to read it out? On meticulous perusal of the application under section 14 of the SARFAESI Act and reading of the same against the agreement so entered into by the creditor with the borrowers, I find that there is no mention of the details of the property in the same agreement. The spaces designated and allotted for the mention of the schedule of the property in the agreement are strikingly found blank. Moreover, the sanction letter so placed before me as regards the concerned loan is also devoid of proper specification of the properties. The properties so described therein are not matching in toto with the properties so mentioned in the schedule of the application so filed under section 14 of the service. That is the ground the London magistrate has taken. Now, my lord, London magistrate has failed to appreciate that the mortgage was made by taking original title deed of the property, equitable mortgage. Now, my lord, kindly comes to the documents he has mentioned. My page 20. And he has recorded that the spaces are blank. I'll show you, lordship. Page 20, my lord has got it. But kindly comes the security column, middle of the page. Security column. Commercial property situated at 26/4 Hindustan Park, PS Goriahat,
Kolkata 29, owner, Greater Kolkata Land and Housing Project Private Limited, residential property, ground floor and portion of first floor at 75 Baliganj Gardens Road, Kolkata 29. Now this is the sanction letter. The observation was made. It is it was
blank.
It was blank. And now kindly comes to the agreement. The schedule of the agreement is at page 41. Have you got it?
Yes.
Nature of security. 75 Baliganj Gardens and 26/4 Hindustan Park. So it is not blank. And now, my lord, I have, being the secured creditor, I have produced the original title deed by which my mortgage was made. Now, the London magistrate decided and adjudicated that this is not mentioned in the agreement, and he failed to record.
No, it's not adjudication. If it is not there, it is not there.
It is there, my lord. And my lord, I have produced the original title deed before the London magistrate, by which I have created the mortgage. This is the recording of this loan. And my lord, I have issued notice under section 13(2). There also, my lord, I have mentioned that entire description of the property. He did not consider. And my lord, in terms of section 14, what can be looked into by the London magistrate?
Yes.
Since it's a ministerial order, he cannot adjudicate.
There is no question of adjudication. He said that these are blank.
Now, my lord, kindly comes to the next page of the impugned order.
What is there in the next page? 105.
105, my lord.
Yes.
The second paragraph. Of course, the authority, while acting under section 14 of the Act, as an executing machinery, but that does not mean that court will blindly allow the prayer so made by the creditor without verifying the documents and without verifying connection between the properties so delineated in the agreements entered into and the properties upon which the order under section 14 of the Act is going to be executed.
Yes.
Being the executing authority does not mean that the authority is mere rubber stamp. Then I have cited certain judgment. And my lord, thereafter, after 1, 2, 3, 4, 5 paragraph, my lord, it starts from here. In this case, as this authority is not absolutely certain about the properties so mentioned in the schedule of the application under section 14 of the Act to be exactly the properties so mentioned in the sanction letter, and so interestingly, astonishingly kept blank in the impugned agreement, this court has got ample power to interfere.
What are the documents? Page 20 was submitted.
Yes. Yes, it was submitted before the London magistrate.
Which portion was kept blank?
I don't know, my lord. I found it is there. And my lord,
See, the court has recorded that it was blank, so it has to be taken. The court certainly, the court is not your other side. The court is not your adversary.
I'm not making any aspersion. I'm on the point of law, my lord.
Yes, if the court has found that the required credentials, the documents were not there, what the court would have done?
It has recorded. Kindly see the page 104, my lord.
Yes.
1, 2, 3, 4, 5, fifth paragraph. Moreover, the sanction letter so placed before me as regards the concerned loan is also devoid of proper specification of the property. The properties so described there are not matching in toto. That means I have to mention, in terms of his observation, I have to mention the entire schedule in the sanction letter.
Obviously, when you sanction a loan, there is a schedule.
Yes, madam, I have given that details of the.
If the court has found that the schedule is not proper, then the writ court will certainly not interfere.
Madam, kindly appreciate that I have.
You make a proper application giving all details.
But only thing, it has not been mentioned in the writ petition whether the document which has been annexed to the writ petition
were there in the
were there.
This is the thing I was inquiring.
When that
kindly appreciate my application.
Listen, once it is rejected on technical grounds, it is there any law which prevents you from further application providing all details?
My document will remain same.
I do not know
because
whether
I'm carrying the original. My documents will remain same. It will not change.
My lord, I appear on the respond of 3, 4, and 5. My lord, my learned friend has just now said that he produced the document.
Kindly comes to page 87.
My lord, kindly come to page 96. The application made before that, my lord, learned magistrate. 96.
Is it blank?
Yes,
Is it blank?
Kindly comes to my application, page 87. Starts from page 87.
Produced before the learned magistrate, and what? Why learned magistrate, my lord, came to the finding. You will also kindly come to page 96. The documents produced before the learned magistrate.
Yes.
My lord, the letter of authorization, loan sanction letter, notice under section 13(2), copies, paper publication, possession notice, and such and such. Well, nothing, the deed was not produced. You will also kindly come to, it is their application. You will also kindly
Yes.
come to
Where are the documents?
Page 89.
Please come.
Kindly allow.
Nothing.
Kindly allow me to
The petitioner
allow me to clear.
is aggrieved
Kindly.
by the order dated 21st September 2024, passed by the learned Chief Judicial Magistrate Alipur in Miss Case number 198 of 2022 under section 14 of the SARFAESI Act, on the ground that that there was lack of description of the property which was the subject matter of the loan agreement. Stop. The learned court has specifically recorded that within quotes, এখান থেকে copy করবেন তো, on meticulous perusal.
But page 104, there is another thing, but last two paragraphs. Be it also mentioned and the next paragraph.
My lord, 105 also, you also kindly consider, my lord, last. But here in the case, it is this authority is not absolutely about the property so mentioned in the schedule.
That due to want of proper specifics, the court was not in a position to allow the said application. Stop. Paragraph. On a perusal of the order of the learned magistrate, it appears that there were several it appears that the details of the secured asset was not clearly mentioned in the application filed before the learned court under section 14 of the SARFAESI Act.
Kindly allow. Kindly come to page 89. It is mentioned, properly mentioned, my lord. Page 89, my lord.
According to the petitioner, all details were properly mentioned. Stop. The writ court is not in a position to verify facts. Stop. Next. It will be open for the petitioner to approach the section 14 authority strictly in accordance with law. Stop. The petition stands dismissed.
In that case, my lord, this matter may be remanded back to the learned magistrate, my lord.
Again, it will be dismissed if you do not have the proper details.
That is why, my lord, I'm trying to show you a lot.
Sorry, you file application giving details.
Then, my lord, may I be allowed to file it afresh, my lord, before the...
I have mentioned it will be open for you to approach the authority.
But this order will not, in that case, my lord, create any problem. And kindly record that much, my lord.
I have recorded 278. আচ্ছা এখানে একটা লাইন প্রাইভেট রেসপন্ডেন্ট ডিড ইউ ফাইল ইওর ওয়াকালাতনামা?
Yes, fine.
ওনার সাবমিশনটা রেকর্ড করে দিন তো। It has been submitted by the learned advocate representing the private respondent that the details of the loan application were not mentioned in the section 14 application, and the documents pertaining to the loan were not placed before the learned court. Yes, 278. Dismissed.
279.
Dismissed. 79.
79. Madam, I am appearing on Union of India.
All right, record your appearance. It's being dismissed. Is the union a party over here? I can see the UCO Bank is there.
My lord.
Dekhi 279 dekhi ekটু Yes, Ministry of Finance is there. Dismissed.
For the respondent number 2.
Who is the respondent number 2?
Ma'am, private party name, private respondent, my lord.
Let me see the file. Did you file your wakalatnama?
Yes, my lord.
You must be knowing. Private respondent, you must be knowing your client by name. What is your submission?
My lord, I'm praying for not today, my lord.
Dismissed.
I'm applying for the petitioner in this matter. My lord, I am for the respondent corporation, my lord.
Respondent?
Respondent financial corporation.
All right.
My lord, I am praying for not today, my lord. The council appearing the West Bengal Financial Corporation, he is not present today, my lord. Kindly make it not today and Monday. Fix the matter Monday.
Monday?
Only one thing I will pray, my lord, 2 documents are to be brought to in record. That one is, my lord, a sale which has been affected by the corporation.
After the writ petition was filed.
After the writ petition came to our knowledge. And my lord, the second e-auction notice upon which the sale was made, my lord, that second e-auction notice is important here, my lord, because they have sold the property, my lord, below the reserve price.
And that was not the challenge in the writ petition.
So, my lord, challenge was, my lord, the first auction notice where the reserve price, my lord, was kept at 2 crores and 7 lakhs base reserve
Yes.
price. And when we wrote a letter to them that we want to pay off our dues,
yes,
they have mentioned in that letter, we have found a buyer of 1 crore 27 lakhs in a letter reply to our letter and requested us to pay off 1 crore 53 lakhs in total adjustment. My lord, after that we filed this writ petition, my lord, where they have said 1 crore 27 lakhs in lieu of reserve price being fixed at 2 crores 47 lakhs. Then, my lord, after this we came to know there was a second e-auction notice where the reserve
if
price.
that be so, then your first e-auction notice goes.
Now, my lord,
the writ petition becomes infructuous.
Because my challenge is, my lord, they have sold the property below the reserve
Yes,
price.
that
remains.
That is in connection with the second e-auction
So, my
notice.
lord, second sale is also below the reserve price.
Yes, so second sale is not under challenge in any writ petition.
Now, kindly sees, my lord, my letter.
Your writ petition was filed when the first sale notice was there.
My lord, in that notice they did
Whatever, you file your supplementary. Ashun Teki. Learned advocate for the petitioner seeks leave to file supplementary affidavit disclosing facts and documents which arose subsequent to the filing of the writ petition. Yes. Learned advocate representing the West Bengal Financial Corporation Limited seeks time and seeks accommodation for the day. Stop. Release the matter on 17th November. The supplementary affidavit may be prepared and circulated by 10th of November.
And my lord, also, my lord, kindly allow me to add the subsequent purchases because any order will be affecting him. So he should be added.
Let me see the maintainability, then addition will be allowed. Nothing now. And you at the same time think it over whether you are going to file a fresh writ
I
petition.
shall consider it and also come.
Because
prayer remains the same, only that
maybe the prayer remains the same if your first notice does not survive and second notice comes in and which is not under challenge, whether you can proceed with the writ petition or not. Next.
And my lord, only one thing, my lord, mind that Tribunal wants on 18th. My lord, can
18th. Dismissed. Dismissed.
Kolkata Municipal Corporation 283.
All right, record your appearance.
Mr. Vendu Bandyopadhyay is for the petitioner in this matter. Pardon me. My lord, he's not coming due to some personal difficulty. Would it be taken up on Monday, my lord?
Yes. Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Released on 3rd of November.
Monthly list. Monthly list, my lord.
Yes.
285.
Dismissed.
286.
Dismissed.
287.
From the statement. 287.
Regarding your appearance, dismissed. Yes, should go to Morindam. Yes.
288.
My lord, 288 item number, I'm praying for a not today because the senior counsel is engaged in another case.
On behalf of whom?
On behalf of the petitioner, ma'am.
I appear on behalf of respondent numbers 1 and 2.
All right, record your presence. Petitioner, accommodation sought for 3rd.
Yes. 29.
Dismissed.
20.
Lord, I appear for the status.
Yes. Dismissed.
291.
Not again dismissed.
292. 93.
Division.
294. 295. 296.
Your Lordship, my senior Mr. Vimal Kumar Shahi will be appearing through the virtual mode.
I'm appearing on behalf of estate, my lord.
296.
My lord.
It's being dismissed for default. Appearance recorded.
Grateful, my lord.
297. 298.
I'm appearing for the state respondent.
Yes.
299. 300. 301.
My lord, I am appearing for Union of India.
Give your appearance, please. It's dismissed.
302.
Your Lordship, my senior advocate, learned Shudip Sarkar, he is out of station for his treatment. I'm praying for adjournment for a week.
For the week. All right. Seeks accommodation. Petitioner. 3rd of November.
Number 3. 4. 5.
For the national highway.
National. Yes. Give your appearance.
6. 7.
But I'm for the judicial office.
Yes. Judicial officer means the state, isn't it?
But,
Are the judicial officers executing powers?
no, but they have made the party the chief judicial magistrate. We have been appointed by the LR.
LR, that means the state authority.
State.
Yes. 307. Dismissed.
8.
Yes.
9. 10. 11. 12. 13. 14. 15. 16. 17. 18.
Additional IG.
19.
For the respondent number.
20. 21. 321.
My lord, I am for respondent number 2 in 322.
2 and 3?
Only for 2.
Only for 2. Who is the respondent number 2?
I'm Muthoot, your lordship, Muthoot Finance.
Did you file your wakalatnama? Has the wakalatnama been filed?
Yeah, lordship.
It has been filed. Please check up, Shailesh. Give your appearance. Yes.
Yes, my lord. In this matter, I am appearing on behalf of the respondents, my lord.
All the respondents?
Yes, my lord.
Who are the respondents?
Steel of Durgapur Steel Plant, CEO Durgapur Steel Plant,
I
CTL
can see the state of West Bengal is there and you say you are for all the respondents?
27, my lord.
327.
20. Oh, I am extremely sorry, my lord. It's 25, 27, my lord.
Yes.
327. Yes, my lord.
Yes.
In this matter, I am appearing on behalf of the respondents, my lord.
All right. Has the steel plant filed wakalatnama?
My lord, but in course of the day, I will file, my lord. The I have already received, my lord.
The
I'll
matter was filed long back. Why didn't you not file it in the meantime?
My lord, I have received it matter before some time, my lord. The fact, my lord, here, my lord, it is relating to estate officer's matter, my lord. Estate officer is also an.
It is being dismissed for default.
I am obliged, my lord.
Next.
My lord, I am led by Mr. Taposh Kumar Banerjee, my lord, in this.
It is you who is here and your name will be recorded. What is your name?
Shambhu Chakraborty.
Give it down in a piece of paper. Your name will be recorded.
328. 329. 30. 31. 32. 33.
These matters are pending from 2024. What can be done? There are 2,500, more than 2,500 matters in the list. Anyway, call it.
34. 35. 36. 37. 38.
Yeah, I know.
39. 40.
I do not call any other matters.
May I only pray for one indulgence, Your Ladyship. Item 301 we couldn't reach on time. It was
For the-
called 301.
For the?
I'm for the petitioner in the matter.
Was your other side there?
My other side,
Anyway, make it not today only.
301. Very deep.
Today only.
Very deep.
My lord, may I submit one thing, my lord? In item number 327, my senior is also appeared in this matter, Mr. Taposh Kumar Banerjee. He is virtually